I hear you.
Oh,
Good to go.
oh. Be on contact. Hey, McLean. You're on mute.
Hit the unmute button. There we are.
Hey, I've been trying to call that extension to just to let 35289. You're not picking up.
Try it one more time. Maybe the ringer is off. I'll look at it while you dial.
But I need to. Okay. There we go. All right.
Nope, still can't. Good morning. Can anybody hear me?
I can hear you.
Yes, I can hear you.
Okay. Yeah. Sorry about the difficulties. We're coming right on. I got you. That's okay. I'll bring it down. Good morning, everyone. Can you hear me?
Ma'am.
Morning.
Yes.
Morning, Your Honor.
Good morning, Your Honor.
Good morning, Judge.
We're having technical difficulties, but we have some technicians here who are getting us together, so I apologize for the delay, but we're gonna get started and try to move along. Gonna blame everything on the rain today, and we'll get started. All right, good morning, everyone. I'm Judge Regina Mincy, and this is our state all-purpose calendar for Thursday, February the 2nd, 2023. Just want to remind everyone that this whole entire proceeding is being live streamed on YouTube as well as recorded. So govern yourselves accordingly and listen to your attorneys. And remember, you do have a right to remain silent. Anything that you state about the facts and the circumstances of your case can and will be held against you, possibly at a later date. So just be careful about your statements and listen to your attorneys. All right, who do we have first? Position 1. Is that where we're going to start?
Yes, Your Honor, position 1, Mr. Brax, he's position 1 and 2.
Gotcha. Okay. All right, Mr. Braggs, it's case number 23 CR 0000348D and 349D, both 2 counts of criminal trespass. I see the state's offer here. This is a negotiated plea, is that correct?
Yes, Your Honor. Both cases are negotiated pleas, and we stipulate to the factual basis, venue, and ID for the purpose of this plea.
Great. And is this ASG Campbell's case?
Yes, Your Honor.
All right, good morning.
Good morning.
Go ahead and get started. I'm in a different spot in a different place, so I'm trying to get everything together here. Give me a
Yes, Your Honor.
Okay.
The state's recommendation on this case, position 1 is 12 months to serve 15 days. Credit for the time served 15 days. The balance is to be suspended. And he is to stay away from 266 4th Street in Atlanta. That's the Georgia Tech campus. The recommendation on position 2 is 12 months to serve 15 days, credit for the time served 15 days, balance suspended, stay away from 112 Bobby Dodd Way in Atlanta. That's also the Georgia Tech campus. And the state's recommendation is that both position 1 and position 2 run concurrently.
Great.
Nothing further.
All right. And who's the PD? Mr. McClain?
That'll be me, Your Honor, Mr. Dotis.
That was a crazy question. I got it. You're there with the defendant at the jail. Okay. And tell me your name again.
Angelo Dotis.
Spell the last name for me.
D as in dog, O, D as in dog, YS.
Thank you. All right, is that your understanding of the plea offer?
Yes, Your Honor. And again, we do stipulate to the factual basis, venue, and ID.
Great. All right. Mr. Braggs, I'm going to take your plea at this time, and I'm going to swear you in and ask you a few questions, okay? Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. And again, I understand, Mr. Braggs, that you want to plead to 2 counts of criminal trespass. Is that correct?
Yes, Your Honor.
All right. And let me ask you a few questions again. Are you under the influence of any medication, drugs, or alcohol at this time?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And
Judge.
you are prepared and agree to waive these rights today, is that correct?
Yes, Your Honor.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
And as to the charge of criminal trespass, 2 counts, how do you plead?
Guilty.
Guilty. And you've heard the conditions that were read. And the biggest thing is that you need to stay away all the way from the Georgia Tech campus. You understand that?
Yes, Your Honor.
All right, and I'm hoping that you will do that, or else you'll end up right back where you are now. Oh, and that is it, just to stay away, nothing else, correct, counsel? All right.
Yes, Your Honor.
All right, so do not go back to Georgia Tech. I assume you're not a student there, correct? Okay. All right, I will accept your plea of guilty to 2 counts of criminal trespass to run concurrent. The balance is suspended of your probation. All right, anything else, counsel?
No, Your Honor.
All right, I will accept your plea. Good luck to you, Mr. Bragg.
So what's going on now?
Next, we have 4 North, Your Honor.
I'm sorry.
Okay, for North, who do we have?
This is position number 23. Leon Smith, position number 23.
All
That's a
right,
negotiated plea, Your Honor.
all right. State, go ahead. Okay, good morning, Mr. Abdullah.
Good morning, Your Honor.
All right.
At this time, the state is, I'm sorry, give me 1 second. I have the wrong screen.
Let me call this case 23 CR 0000540Y. Leon Smith, you're charged with 1 count of theft by shoplifting. That offense date is February 13, 2022.
Yes, Your Honor. At this time, the state is requesting a time served sentence of 12 months to serve 164 days with credit for time served for 164 days, balance suspended.
All right. And Mr. Dotis, is that your understanding of the plea?
No, that's my case, Your Honor.
Oh, I'm sorry, Mr. McLean.
That's fine. Yes, Your Honor, that is our understanding of the terms of the plea bargain, and we stipulate to venue and ID and the sufficient facts.
All right, good. All right, Mr. Smith, raise your right hand for me. Do you affirm that the
Yes, ma'am.
Okay, do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, you put your hand down. I'm gonna ask you a series of questions in order to accept and take your guilty plea, okay?
Yes, ma'am.
All right, and so I've got to ask you a few questions. The first one being, are you currently under the influence of any medication, drugs, or alcohol?
No, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
And do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
You're prepared and agree to waive these rights today, is that correct?
Yes, Your Honor.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
All right. And so again, as to the charge of criminal trust, as to the charge of theft by shoplifting, how do you plead?
Guilty, Your Honor.
All right, I will accept your guilty plea. And it's just a time served, balance suspended sentence, so you will be free to go after the jail processes you out, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
Next, we have courtroom 1, position number 8, Mr. Durham.
Okay,
He's the conflict with Ms. McLeod.
thank you. This is case number 23, CR 0000389C. Mark Durham, you're charged with 1 count of simple battery against a police officer, police dog, corrections or detention officer, and simple battery family violence. That offense dates January 20, 2023. State?
Yes, Your Honor. The state's offer for Mr. Durham is going to be 12 months to serve, 240 days, credit for the time he served, 14 days. The balance is to be probated. He's to have no further contact with Mercedes Cook. He's to stay away from 1945 Monroe Drive Southwest, and he's to complete a 24-week family violence intervention program. I didn't get a response back to whether or not that offer was accepted, but that is the state's offer.
All right. And Ms. McLeod, good morning. How are you?
I am fine, thank you, Your Honor. The state rejects that offer. The defendant rejects that offer. My client definitely rejects that offer, Your Honor.
Okay.
He would like to be arraigned this morning and to enter his plea of not guilty.
All right, so we will conduct that arraignment, Ms. Campbell. Let's go ahead and do that. Mr. Durham?
Yes, ma'am.
All right. And so again, Mr. Durham, I understand, and you've heard the state's offer, and you are rejecting that offer. Is that correct?
Yes, ma'am, I am.
Counsel waive a formal reading of the accusation?
I do, Your Honor.
Okay, thank you. And so again, Mr. Durham, you have been charged with the offense of simple battery against a police officer, dog, or corrections detention officer, and a second count of simple battery family violence. And you're being formally accused of these charges against you. And each charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000 for each charge. This case is going to be reset for a jury trial, and the trial will be scheduled by the state court judge to whom the case is assigned as further notice for trial. Make sure that you keep your address and phone numbers current with the clerk's office as well as your attorney, and that will be sufficient. And at the jury trial, you will have a right to an attorney, which you have presently. You do not have the burden to prove the charges at trial. The state, represented by the Solicitor General, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in the case. If they do get a conviction, you could face again a sentence of up to 1 year in prison or a fine of $1,000 for each charge that could run concurrently or consecutively. Based upon this information, do you plead not guilty to these charges?
Absolutely, Your Honor.
All right, I will accept your plea of not guilty. This case will be reset for trial. The case is arraigned for the notice for trial. All right, thank you.
Thank you.
All right, thank you.
Next, we have add-on 1, Mr. Derek Pass.
Okay,
That's ready for a negotiated plea, Your Honor.
all right. This is case number 22 CR 0004428G, Derek Pass, in charge of 1 count criminal trespass and damage to property, offense date 7/9/2022. And I understand that you are going to accept the plea. Is that correct? All right, state, tell me what the plea is.
Yes, Your Honor. The state's recommendation is 12 months to serve 106 days. Credit for the time he's already served 53 days. The balance is to be probated. As conditions of his probation, he is to do a mental health evaluation and treatment, as well as have no further contact with his mother. Her name is Lynn Toricia, and that is spelled LYNTORICIA. Her last name is Pass. He is to stay away from 1244 Westboro Drive Southwest in Atlanta. And he is also to pay his mother $500 in restitution. But again, no further contact at all.
And so how will he get the restitution to the mother?
It'll either have to go through probation or the court.
All right,
Then we'll get it to the victim.
right, it'll go through probation, okay. Because you did say balance probated. And so he has to complete these other conditions as well. Is that your understanding, Mr. McLean?
It is, Your Honor.
All right, Mr. Pass, I understand that you have listened to the plea offer. Is that your understanding as well?
Ma'am?
That's your understanding of the plea offer?
Yes, ma'am.
All right, and Mr. McLean, you stipulated?
Yes, we stipulate to venue, ID, and factual basis.
All right, and I'm going to swear you in and then ask you a series of questions, Mr. Pass, to accept your plea, okay?
Yes, ma'am.
Raise your right hand for me. Do you swear to that this testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you presently under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked or affected because of this guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of criminal trespass and damage to property, how do you plead?
Guilty.
All right, and you understand the conditions, correct?
Yes, ma'am.
Okay, you're to have an MHET and you're to stay away from 1244 West Barrel Drive, which I think is your mom's home. You understand that?
Yes, ma'am.
And probation will speak to you about the $500 restitution fee that you must pay. All right?
Yes, ma'am.
All right, so good luck to you, and that will conclude this case, and your plea is accepted.
Oh, Your Honor, could the court give him a break financially on the probation fees for a significant period of time as financial hardship on him?
I will waive 6 months of the probation fee.
Thank you, Your Honor.
Next, we have position number 5, Mr. Dakota.
All right, this is David Dakota, 23 CR 0000331F. You're charged with 1 count theft of services. And the offense date is January 18, 2023. State?
Yes, Your Honor. The offer for Mr. Dakota is 12 months to serve 15 days, credit for the time served 15 days. The balance is to be suspended. He is to pay restitution in the amount of $67 to Brooklyn Cafe. And he is to stay away from the Brooklyn Cafe, which is located at 220 Sandy Springs Circle. Nothing further.
All right, Mr. McLean or Mr. Jonas, which?
This will be me, Your Honor. Yes, this will be a non-negotiated plea. The only issue is we're fine with all of the conditions except for the $67 restitution amount. I don't have a legal basis for that amount. I haven't seen any receipts or anything else of the matter. So we'd ask to go forward with the plea on all other conditions except the restitution.
And Your Honor, just to put the facts on the record, according to the incident report, as well as the warrant, this defendant did dine at the Brooklyn Cafe on January 18th of 2023. According to the cafe workers, he ate $67 worth of food and he was unable to pay the bill. He did admit to the arresting officer that he came to the restaurant with no money or credit cards to pay for the bill. So that's why he was charged with theft of services. And so as to the public defender's argument as to he doesn't have a receipt, that is correct. We have not provided a receipt, but that is in the incident report and that is in the warrant packet, stating that the amount that was owed to the restaurant was $67. And I would like to note for the court that the defendant does have a prior theft by receiving conviction from 2021. Well, actually it's a first offender probation, but it was felony theft by receiving. And so the state believes that in light of that prior conviction, the state's recommendation is offer is very reasonable. Nothing further.
All right, Mr. Dotis, do you have any response to that?
Again, our only issue is the restitution amount. I know the warrant claims the bill total was $67, but I don't know where that amount's coming from. So again, that's our only issue with this. We don't have that.
What is Mr. Dakota's, he is how old and I'm assuming he's unemployed? Can you tell me a little bit about his background?
1 second, Your Honor.
And I did hear his criminal history, so.
Yes, Your Honor. Mr. Dakota is 24 years old. He's lived in Georgia for most of his life. He's been in the Atlanta area since October of 2022. He currently works for Dolphin Enterprises, where he sells cars, as well as the Global Logistics, where he provides logistics solutions. He also has some support in the area with Miss Jasmine Woodson, who I've been in contact regarding this. He will have support when he gets out. And he is a part of this community and working hard. Again, our only issue is, the restitution amount and getting a legal basis for that. He also has two-year-old twins in Florida, which he provides child support for. And nothing further from us, Your Honor.
All right. Normally, Ms. Campbell, we generally do have a receipt of some sort that is provided from the the victim. And so I am a little concerned that we don't have that, although with the incident report and then the accusation, we do have those, that amount in both, correct?
Yes, Your Honor. It's in the warrant too.
And in the warrant, you did say a warrant, thank you, okay, and it's in the warrant. So the warrant is sworn to as well. So I'm going to go ahead and ask that the $67 be repaid to the Brooklyn Cafe or through probation. But then probation is suspended. But is it possible that that $67 could be paid directly to the cafe?
You getting,
I guess via your attorney, because you have a stay away provision of this plea offer.
I'm not sure how our office would handle that. I'm happy to find a way. I don't know if Ms. Campbell has any input on this. I haven't handled restitution for something like this before when we don't have a probation period.
You can get it to our office and our victim witness department will take care of it. So if you can get it to us, we'll get it to the.
Okay, perfect. I can coordinate with that. Thank you, Ms. Campbell.
Okay,
So the defendant will not go on probation at all?
and it says balance suspended.
Because usually when it's a restitution, the defendant goes on probation and then he pays it through the probation department.
Until it, yes. So, Ms. Campbell, can we change and Mr. Dotis, and as soon as he has paid that restitution, then his probation will be terminated?
Yes, Your Honor, I would be okay with that.
That way we'll do it through the proper channels, and thank you, Ms. Champion, for that. And so as soon as he pays that fine or cost back to probation, then they will get it to the victim, and then he will be, his probation will be terminated at that time. All right, so we ready to take the plea?
Yes, Your Honor, we're prepared to go forward with the plea. Thank you.
All right, and so, Mr. Dakota, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, and I'm going to ask you a series of questions in order to accept your guilty plea. The first one being, are you under the influence of any medication, drugs, or alcohol at this time? Sorry,
I take medication every single day.
anything that is not prescribed,
No.
okay? Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Can you repeat that?
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you're prepared and agree to waive these rights today?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with a full understanding of the charge against you?
Yes.
And again, I will accept your guilty plea. And how do you plead to the theft of services?
Guilty.
All right. And again, you're getting credit for time served. The 15 days is 12 months to serve, 15 days credit for time served. Balance will be probated until you pay the $67 restitution that will go to the Brooklyn Cafe. Probation will advise you of that. And you are to stay away from the Brooklyn Cafe at 220 Sandy Springs Circle. Do you understand that?
Yes, Your Honor.
And as soon as you pay that $67 through probation, then your probation will be terminated at that time or suspended. All right?
All right.
All right. So good luck to you, and that concludes this plea.
Thank you.
All right.
Next, we have position 6 and 7, Mr. Dugan. Dogan.
Goodbye.
Sit on the second row. Put that one. Come on, Mr. Dogan.
This is 21 CR 004947J. Eric Dogan, charged with 1 count of fare evasion, possession and use of drug-related objects, and giving false information to law enforcement officer. That offense date is 9/17/2021. In the second case, 23 FTA 000061, charged with failure to appear. And that offense date was 12/21/2022. All right, and so that's what we have before the court today. Ms. Campbell?
Yes, Your Honor, the state's offers 12 months. It's actually updated since this morning. 12 months to serve 4 days, credit for the time he served 4 days, and he's to comply with all the active MARTA suspensions in place. That's to position 6, and that is to be concurrent on all 3 counts. The fare evasion, possession and use of drug-related objects, and giving false name to a law enforcement officer. As to position 7, pursuant to him entering a plea today, on position 6, the state would be no processing position 7, the FTA charge, nothing further.
All right, thank you. Mr. Dotis, is that your understanding?
Yes, Your Honor, that is my understanding. Mr. Dogan would also request to use his NOLO on position 6.
Okay, he's not pled NOLO in the last 5 years.
To my knowledge, I spoke with Mr. Dogan. He has not used his NOLO in the last 5 years.
All right. Do you have any conflicting testimony, ASG Campbell?
No, Your Honor, I don't.
All right, I will allow him to use his NOLO plea for position 6. Position 7 is no pros. All right, Mr. Dogan, are you ready to take the plea today?
Yes.
All right, and Mr. Dotis, do you stipulate?
Yes, Your Honor. We stipulate to the factual basis, venue, and ID for the purpose of this plea.
All right, Mr. Dogan, is it Dogan?
Yes.
Okay, it's Dogan, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. Gonna ask you a series of questions in order to accept your guilty plea. The first one being, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yeah. Yes, ma'am.
All right, and do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes. I understand.
Has anyone told you that you'll receive a lesser sentence for pleading?
No, ma'am. No, ma'am.
Has anyone promised you anything? to
No,
plead?
ma'am. No.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes. Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full
Yes.
understanding of the charges against you?
Yes, ma'am.
All right, I will accept your plea as to fare evasion, possession, use of drug-related objects, and giving a false information to a law enforcement officer. How do you plead?
No.
And I'm sorry, I should have said NOLO.
No. Yes, ma'am.
I apologize.
It's all good. You good, ma'am.
All right, want to be specific enough on the record that I am accepting your NOLO plea.
Yes.
Those 3 charges. And the conditions of your probation are again, that you are to comply with all active MARTA suspensions. And I'm not sure how long the current suspension is, but whatever that is, unless ASG Campbell or Mr. Dotis has that information, they will relay that to you. And you are to comply with that to stay off of MARTA for however long that suspension goes. And then these 3 charges will run concurrent. As long as you stay away from MARTA, you won't be back here. Do we have any information on how long the current suspension is by chance?
Your Honor, I believe it's expired, the one that was in place, because this case is an older case, to be honest, and I believe it was from 6 months from the incident date, and because he FTA'd on this case, we're past 6 months. So I don't know if he had picked up any additional ones, but the one that was in place at the time of this incident, it is expired.
Okay,
That's my understanding as well, Your Honor. I didn't see any active suspensions, but that's fine, wording it that way.
okay. All right. So again, Mr. Dogan, as long as you are a good citizen on MARTA, you can probably go back and do that. I always tell the defendants to maybe check with the MARTA corporate office to make sure there are no suspensions on you that you're unaware of, so that you don't get out and get rearrested again very quickly, not knowing that you are under suspension. So you can verify that with MARTA to make sure, okay?
Yes, ma'am.
All right. Good luck to you, and that will conclude your plea.
Next, we have probation position number 1, Mr. Seaborn. Stacy Seaborn.
Position, oh, that's on the probation revocation calendar?
Yes, Your Honor.
I'm sure probation is not going to argue with me to say, hey, we haven't finished our state all purpose, but we'll go ahead and get that out of the way, because that's the only case you have, right, probation?
Yes, Your Honor.
All right, we'll go ahead and do that one. All right, this is case number 23 PV 000082 with Stacy Seaborn. The charge is failure to appear, since dated 11/9/2022. We have a second case, which is 19 CR 006927B. Again, Stacy Seaborn charged with 1 count of battery family violence, and that offense date is April the 1st, 2018. All right, you may proceed.
Yes, Your Honor. Mr. Seaborn was sentenced on March the 9th, 2021 to 12 months. This case was consecutive to his first case with Judge Edie. As of today, Mr. Seaborn has not reported to our office, provided proof of completing the domestic violence classes. This case has 4 months, 23 days remaining. Probation recommendation is to revoke his remaining time on probation.
All right. Mr. Dotis?
Yes, Your Honor. I spoke with Mr. Seaborn and I spoke with his wife last night about the situation. Mr. Seaborn bit off more than he could chew with the probation, and life got in the way and he wasn't able to complete the conditions, and he understands that. And he understands that the probation officer's recommendation is to revoke. He is at the mercy of this court and asking to consider something less than the 4 months and 23 days just to finish the balance. So we would just ask the court to consider something less than the full 4 months, but he does understand that to avoid any future issues and to put this issue behind him entirely, that it's in his best interest to just serve the time instead of going back on probation. But he would ask for something less than the 4 months.
All right. Probation, do you have any of his criminal history?
I do not, Your Honor.
All right, is pretrial here?
Yes, Judge, give me just a moment.
All right, thank you.
Judge, in regards to Mr. Seaborn,
Yeah.
30 arrests in Georgia, 1 in Tennessee, 2 felony convictions. He has 4 FTAs, 04, 06, 2018. 2021, he has a history of probation and parole violations. 09 parole, 2012 parole, 12 parole, 12 parole, 12 probation, 16 parole, 14 probation violation, 2018 probation violation, 17 probation violation, 17, 2018, 2019, 2019.
All right, thank you. All right, I am going to agree with probation that we are going to revoke and he must serve the rest of his time, the 4 months and 23 days. Is that correct, probation?
Yes, Your Honor.
Based on that history, I cannot do anything less than that.
Thank you, Your Honor. We understand that. I would also like to note on my probation revocation calendar for Mr. Seaborn, I also have a second case for FTA for fingerprintable charge. Does that just go away? Does that get, I don't know, do we need to null cross that or?
Probation or state? Mr. Jordan.
We'll need an order for that TV case as well. That was the warrant, remember, that he was arrested on.
Okay. And so that, who takes care of that, Mr. Jordan?
I really don't know, but I can do it with dismissal order for you. What's happened with the probation case? I was on the phone, I wasn't listening.
We're revoking and he's going to have to serve 4 months and 23 days, the rest of his time.
Also, he's gonna spend the rest of the time in jail.
Right.
So the probation warrant is what he's actually holding on. So I guess the probation warrant can be dismissed and then the hold will be placed on the CR case.
Okay. Is that your understanding, ASG Campbell?
Yes, Your Honor, and I can assist with if you guys need a no pros on the FTA.
Okay, all right. That will be good. That will kind of straighten that out at the jail as well. Anything else, Mr. Dodas?
No, thank you all for clarifying that.
Right. And anything else, Ms. Harris, with probation?
No, Your Honor, I just need you to sign off on the warrant dismissals and the petition. Can I come to the office you're at?
Yes, I am on the second floor with Mr. Jordan. I'm not in the courtroom.
First floor.
The first floor, is it Ms. Lewis'
K150.
office?
Oh, yes, Ms.
Yes.
Lewis. I'm sorry.
Okay.
Yes, yes,
Okay.
you can find me. They're doing ORCA in the courtroom this morning. So.
Okay, yes, Your Honor, I'll be right over. That
All right,
concludes.
thank you.
May I be excused?
Yes, you may. Thank you.
Thank you.
Next, we have 5 North, Your Honor.
Okay. Who do we have?
Position 3, Mr. Brown.
All right, this is case number 23 CR 0002444C. And Mr. Brown, and I think that's Zydario, you're charged with 1 count of criminal trespass, offense date January 13, 2023. Understand that this is a negotiated plea. Is that correct, ASG Campbell?
Yes, Your Honor, that's my understanding as well.
All right, tell me what the plea offer is.
The offer is 12 months to serve 42 days, credit for the time he's already served 21 days. The balance is to be suspended and he's to be instructed to stay away from 4995 Cascade Hills Circle Southwest in Atlanta.
Okay. And so, Mr. McLean, is that your understanding?
This is my case, Your Honor.
I'm sorry, Mr. Doty.
Sorry about that. I was on mute earlier. Yes, Your Honor, that's our understanding. We do stipulate to the factual basis, venue, and ID for the purpose of this plea.
All right. And so, Mr. Brown, are you wanting to plead guilty today?
Yes, ma'am.
All right, and I'm going to swear you in and ask you a series of questions in order to accept your plea. Is that your understanding of the plea offer?
Yes, ma'am.
All right, raise your right hand for me. You affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
Okay.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
So as to the charge of criminal trespass, how do you plead?
Guilty.
All right, and your conditions again, 12 months to serve, 42 days, credit for time served at 21 days, your balance will be suspended, and your condition is to stay away from 4995 Cascade Hills Circle Southwest. You understand that?
Yes.
And as long as you do that, hopefully you won't be back here. I will accept your plea. Good luck to you. Anything else, counsel, I need to take up?
No, Your Honor.
All right, thank you.
Okay. No, we need love and I'll put you.
And who do we have next, deputies?
Next, we have position number 4, Mr. Daniels.
All right.
Question, where we go? Can you mute for a second? I have one, my client has one question, Your Honor, if we could have a second.
I'm sorry?
Mr. Daniels just wanted to ask me one question before we proceeded.
Oh, okay.
Thank you, Your Honor. Thank you, Your Honor. We're ready to proceed.
All right. This is case number 23 CR 0003688. Demetrius Daniels, you're charged with 1 count of battery, family violence. This date is January 19, 2023. I understand that this will be a plea. Is that correct? Or no? I'm sorry, waive arraignment, jail jury, address bond. What are we doing today?
Yes, Your Honor. Mr. Daniels would like to waive his arraignment and be heard on bond.
All right, I'm sorry, we're going to waive arraignment. You've been formally charged with this battery, family violence, and now we're going to address bond, pretrial.
Moment, Judge, let me pull him up.
Okay.
Demetrius. Demetrius Daniels has 4 arrests in Georgia. He has a criminal trespass in 2019, an FTA in 2019, he may have an open case from 2020 for arrest from Georgia State University for obstruction and theft by receiving, drive without a valid license from 2020. And he has one arrest in Alabama that's probably open as well for theft by receiving stolen property from a July 29th, 2022 arrest. Nothing further.
All right, thank you. All right, go ahead, Mr. Dotis.
Yes, Your Honor. Mr. Daniels is 24 years old and he has been in custody for 14 days and his current bond is a $10,000 cash bond. The change in circumstance that brings this up is his time in jail and his inability to afford the current $10,000 cash bond. I don't believe Mr. Daniels is a flight risk. I have a good address for him that I was able to verify, and I'm happy to put that in the chat. He'll be living with his cousin, Antonio Pendleton, who I spoke with yesterday, and he's going to have his, Mr. Daniels has Mr. Pendleton's support as well as all of his family in Georgia on getting back on his feet. He also has an aunt in McDonough, August Edwards, who will be supporting him. Mr. Daniels has spent the last 5 years in Atlanta, and before that was in Alabama. He's currently working as a baggage handler with Delta, and he's doing his best to make sure that job is being held for him. And if not, he understands that he'll need to find something else. He does have the support of his family and parents who will support him while he tries to get back on his feet upon his release. Mr. Daniels graduated from high school in Alabama before moving to Georgia. I don't believe he's a risk of intimidating any witnesses or victims. He understands that he can have no further contact with the complaining witness, Janira King, and will need to have a stay away from the 3525 Creighton Road. And I've made that very clear to Mr. Daniels. I don't think he's a risk of being a threat to the community at large. I didn't see any violent history, and he's also open to any conditions the court deems appropriate to ensure the safety of the community. We heard the 2019 FTA. I don't think anything more recent has been addressed. I didn't hear any VOPs. I don't think he's a risk to commit any new crimes. Regarding his prior criminal history, he does have some Georgia cycles as well as a possible case in Alabama. I didn't hear any violent history. So I don't think he'll be an issue of any more violent acts. And I believe there was no evidence that he did not cooperate during the incident alleged in the warrant. And for these reasons, we're requesting a $5,000 surety bond that will allow Mr. Daniels to get back on his feet and mount his defense effectively outside of the jail system.
All right, ASG Campbell.
Yes, Your Honor. I want to supplement this defendant's history. He does have a 2020 possession of a firearm during a commission of a felony here in Fulton County. That case is currently open and he has a no bond hold on that case. It's 20 SC 1750. Hold on one second. 1750. 175007. And so he's got one count of possession of a firearm during the commission of a felony. He's got one count of selling MDMA or possession of MDMA. And Your Honor, I did look at the bond order on that case, and it looks like he had a $6,000 signature bond through the jail that was given to him on February 4th of 2020. And it looks like he was ordered to have no alcohol, drugs, or weapons while on bond. That is relevant to the instant matter because the facts of this case are that on the date of January the 19th of 2023, at the location of 3535 Creighton Road Southwest, this defendant did physically attack the victim in this matter. Her name is Janira King, and Janira is his heavily pregnant mother of the defendant's child. He did push her and he slapped her while she was in her pregnant state. which caused her to sustain bruising on her shoulder and her foot. The victim was actually texting her friend, and the victim was texting the domestic violence hotline because she's deathly afraid of the defendant. She did advise her friend via text message, and we have those text messages, that the defendant had a gun in the house and that she was afraid of him because he had been threatening to kill her with the gun. She even sent the picture of the gun to her friend. We do have a picture of said gun. Again, he was ordered to have no weapons while on bond for possession of a firearm during the commission of a felony in 2020. So he's not supposed to have a gun. And we have had contact with this victim. She does state that he has been calling her from jail, threatening to shoot up her house and to harm her and her roommates once he is released. She has stated that this is not the first time the defendant has threatened to shoot her, and that she actually even filed a police report stating that the defendant has threatened to shoot her, but the defendant was not arrested. She said that every time she tries to leave the defendant, he threatens to shoot her again. And she stated that this incident actually began on January 18th of 2023, and it continued all the way up into the 19th. So this was a lengthy ordeal of her being beat and threatened by this defendant on that day. She states that she wants no contact with him. She wants him to stay away from her residence, and she will not be on Zoom this morning, but she did want to give this information to the court for your honor's consideration. Lastly, I would note that your honor did address bond for this defendant on January 20th. You did give him the $10,000 cash bond on that date, your honor. And I believe that this bond is appropriate. You said it needs to remain in place because there has been no significant change in circumstances whatsoever. He's still a severe danger to the victim. He's on bond for a firearm charge, and here he is allegedly using a firearm again against his pregnant girlfriend, threatening to shoot her. And at the bare minimum, we have that he is alleged to have beat her up while she was pregnant. So the state is going to be objecting to a bond modification on that basis, nothing further.
All right. Anything else, Mr. Golders?
Your Honor, Mr. Daniels maintains his innocence in this case and wants to be able to mount his defense and fight these allegations. Again, a gun is brought up. There's an allegation that Mr. Daniels threatened to shoot the complaining witness, but there's no evidence that there was a gun or anything, or that he violated his bond condition by having a gun. I understand that there's the state is bringing up some jail calls and communications. I don't have any information on that. That's something that I think we can deal with down the line. But at this point, based on what's in the warrant and Mr. Daniels' inability to pay this cash bond and keep him in jail, unable to mount his own defense and be a part of that, we are asking for the bond to be lowered to allow this Mr. Daniels to get out and be a part of his defense.
Based on the criminal history and the facts of this case, I have some grave concerns for the victim in this case. It's been 14 days, and I think at the time that I initially heard it, I wanted to make sure that there had been some cooling off, but I still want to make sure that the victim, the pregnant victim in this case, is going to be safe. And I'm hearing from the state that she's obviously terrified and afraid. He has a felony hold, correct?
Yes, that's correct. It's a no bond hold.
No bond hold. I am not going to reduce the bond at this time. I am going to keep the bond at the $10,000 cash bond.
Understood, Your Honor.
All right. That will conclude this case.
Next, we have position number 9, Mr. Fennick.
Position 9, I have 23 CR 000-545J, Michael Fennick, charged with 1 count of terroristic threats and acts. Offense date 10/6/2021. And I understand this is waive arraignment, jail jury. What's the,
Yes, Your Honor.
and then is there going to be a plea, or we're just going to address bond, or it says waive arraignment? What's the status of this case?
Your Honor, to my knowledge, this isn't what's holding Mr. Fennick, so we were not planning on addressing any bonds or matter.
All right, State, ASG Campbell, what is your understanding of the disposition of this case?
Yes, that's correct. He's being held on a felony probation violation, so he's not being held on this charge at all.
Okay. All right, we will move forward then.
Thank you, Your Honor. And I'll probably just keep calling about your probation stuff. Okay. All right.
Next, we have position number 10, Mr. Gibson. Mr. Gibson?
This is case number 23 CR 000-332J. Arthur Lee Gibson, charged with 1 count of criminal trespass. Offense date is January the 18th, 2023. And is this going to be a negotiated plea?
Yes, Your Honor, it will be.
All right, State.
Yes, Your Honor. The state's recommendation is 12 months to serve 16 days, credit for the time he's already served 16 days. The balance is to be suspended, and he is to stay away from the Georgia Tech campus located at 266 4th Street Northwest in Atlanta. Nothing further.
All right. All right, Mr. Dotis.
Yes, Your Honor, that's our understanding of the offer, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea.
Okay. Hold on 1 second. All right, we're back on the record. And again, Mr. Dotis, that's your understanding of the negotiated plea?
Yes, Your Honor, it is. And again, we do stipulate to the factual basis, venue, and ID.
All right, and Mr. Gibson, is my understanding that you wish to plead guilty to 1 count of criminal trespass? Is that
Yes.
correct?
Yes, that is correct.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, you put your hand down. And I need to ask you a series of questions in order to take your plea. The first one being, are you under the influence of any medication, drugs, or alcohol at this time?
No, I'm not.
Are you satisfied with the services and representation of your attorney?
Yes, I am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
I understand.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, I do.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Mhm.
And you are prepared and agree to waive these rights today, is that correct?
Yes, I'm prepared.
All right, and has anyone, told you that you'll receive a lesser sentence for pleading guilty?
No,
Has anyone promised you anything to plead guilty?
no, they have not.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
I understand.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, I do.
As to the charge of criminal trespass, how do you plead?
I plead guilty.
All right, and again, your conditions, 12 months to serve 16 days, credit for time served 16 days, balance suspended. And your condition is to stay away from the Georgia Tech campus, 266 4th Street Northwest. It's a pretty vast area. So if you would just please stay away from that campus, I assume you're not a student. So if you do that, you won't hopefully end up back down here. Is that
It's understood, Your Honor. Thank you.
okay? Understanding? All right, good luck to you.
Next, we have position 19, medical.
This is 23 CR 0000226E. Nakia Lee, charged with 1 count of theft by taking, offense date, November the 3rd, 2020. State,
Your Honor, before we proceed on that, I do need to speak to her. This is McLean. I wondered if there's a phone number which I can call because the desk phone next to the iPhone on which I'm doing Zoom does not ring, so I have to ring out.
okay?
And we do not have a phone up here. We had to walk to the other side of medical for her to get on Zoom. We do not have a phone in this little office, so you may have to do a breakout session.
Wow.
Okay, a breakout would be fine.
All right, Ms. Champion, not Ms. Champion, who's my Zoom master?
Do you need a breakout room with this?
Yes, Mr. Jordan. Mr. McLean and the medical in the breakout.
Is it medical or self-funded?
I think it's medical. Isn't it medical?
Medical, okay.
Mr. McLean?
Medical is position 19.
Right, medical.
Right.
Okay.
So Mr. Jordan is gonna put them in a breakout.
Thank you.
Okay, we're gonna go to ACDC. So
Okay.
is that Mr. McLean's also?
Angie Spurl, yes, she was going to announce her decision this morning. We discussed it and she's going to decide whether to go forward with the not guilty or.
I wanted to take the plea deal, but I'm not sure if I say guilty or not guilty for that.
He froze, so he might take a while for him to come back.
You're Ms. Spurl.
Yes.
So your attorney wants to know, are you going to take the plea deal or not?
So Mr. McLean, looks like he dropped out, so he won't even hear her. His screen is frozen, so it looks like he dropped out.
Oh, shoot, okay. Hold on a second. Let's see if he'll sign back in. Oh, there he goes. Mr. McLean? Nope.
Okay. I wanted to take the plea.
Hold on. Your attorney, his screen is frozen, so hold on a second. See if we can see him signing back in. Or Mr. Jordan, okay, let's see. He signed off, Mr. Jordan?
He's off altogether now, so I'll let you know when he comes back on. Oh, no, he came back.
Right, he may be trying to sign back in. Hold on.
Your Honor, while we're waiting for Mr. McLean to log on, do you want to go to position number,
There he
30?
is.
Oh, there he is? Okay.
He's back.
Okay, I'm back.
Yes, I saw he froze, but I thought maybe he's just not moving, so I tell you, sorry about that, I understand. And Miss Sparrow is here, and she was getting ready to say something, whether she was taking the plea or not. We can't hear you, Miss Sparrow.
I said, that yes, I wanted to take the plea deal.
Okay, and you want that, you remember I explained to you the difference between unnegotiated plea and a negotiated plea and the advantages and disadvantages and what the goals would be. If you want to do the negotiated or the unnegotiated?
Would it be possible if you could give me a slight rundown again of what the differences between them are?
The unnegotiated plea is when you ask for something different than what the state is asking for. It's not a handshake deal with the state. They're asking for what they want and you're asking for what you want. And those two things are different. It is not guaranteed and the judge is free to sentence without allowing you to withdraw without allowing you to withdraw your plea. The judge is free to sentence you to anything within the limits of the law. However, a negotiated plea is one that you can withdraw if the court feels it is unfair once the judge hears what the deal is.
Can I go with the negotiated one?
Certainly. You and I discussed it thoroughly last night. So if you understand that will be 2 consecutive sentences, it'll be 24 months probation, 30 days extra days of jail on one, 14 extra days of jail on the other, totaling 44 extra jail days, and you will be released, according to my calculation, 44 days from today to go on probation and start your FVIP class.
Yeah.
Okay, that's a negotiated plea, Your Honor.
All right, thank you. I'm trying to figure out, deputies, what'll be more convenient for you because Mr. McLean needs to go into a breakout with medical. Then we've got his plea pending. Can we do one of Mr. Dotis's cases or do you want to take his plea first? Because it's still going to hold you up in medical. You all tell me logistically how you want to do it.
Sorry, Your Honor, the deputy was taking a phone call. If you could repeat that for Milton.
I was going to ask the jail logistically how you wanted to handle it. I have Ms. Sparrow here and Mr. McLean, but Mr. McLean was going to go into a breakout with medical to talk to her, to that defendant, and he's also got a plea pending, but then we have Mr. Dotis.
Position right here in courtroom 2, Mr. Hambrick. He's position 13.
Okay. We'll do that and let Mr. McLean speak to his client for a second.
Yes, Your Honor.
Okay. All right, hold Ms. Sparrow, Mr. McLean, Mr. Jordan, can you go ahead and put Mr. McLean in medical in a breakout? All right. This is position 13, 23 CR 0000369J, Roshan Hambrick, charged with 2 counts of criminal trespass, offense date January 18, 2023. This is a negotiated plea.
Yes, Your Honor.
All right, state. Is that Mr. Abdullah? No?
Yes, Your Honor.
Okay, go ahead.
Is this still for,
13.
I'm sorry, did you switch to position 13?
I did. I'm sorry.
Okay, this isn't me, I'm sorry.
Juggling a little bit, yes.
Oh, okay. 13 is my case.
Oh, sorry.
That's okay. This is Mr. Rashawn Hambrick.
Yes.
Okay, the state's offer is 12 months to serve, 30 days, credit for the time served, 15 days. The balance is to be suspended and he's to stay away from 158 Walnut Street Southwest. And there's actually 2 counts of criminal trespass due to the fact that he criminally trespassed at 2 different places on the incident date. So there is also
594 Parsons Street.
yes, I'm also asking for a stay away from that address as well.
Okay,
Right, I went over that with Mr. Hambrick, so we're clear on that.
okay, and give me that second address, 594
Parson Street.
Parson.
That's correct.
All right, and they're gonna run concurrent on both counts, okay? All right, if that's your understanding, I'm ready to take a plea. Mr. Hambrick, are you ready to plead guilty to 2 counts of criminal trespass today?
Yes, ma'am. And Your Honor, we also do stipulate to the factual basis, venue, and ID for the purpose of this plea.
All right, thank you. Raise your right hand for me, Mr. Hambrick. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and put your hand down. Are you presently under influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
Do you understand that you're giving up and waiving the right to remain silent and to not testify against yourself?
meeting is being recorded.
Okay, and do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
And as to the charge of 2 counts of criminal trespass, how do you plead?
Plead guilty, ma'am.
All right, and again, 12 months to serve, 30 days credit for time served, 15 days, balance suspended. Stay away from 158 Walnut Street Southwest, and also to stay away from 594 Parsons Street. Do you understand what you need to do while you're, as part of the plea conditions?
Say it again, ma'am.
You understand what you need to do as part of the plea conditions? Stay away from those 2 addresses that I just read.
Yes, ma'am.
Okay, if you do that, you'll be okay. All right, I will accept your plea. And anything else we need to take up, counsel?
Nothing from us, Your Honor.
All right, thank you. All right, remember your conditions, Mr. Hambrick. Good luck to you.
Medical for position 19, Your Honor.
Okay.
So it appears that 19 will be a negotiated plea, Your Honor, and that is Ms. Nakia Lee. And of course, 24 and 25 will also be a negotiated plea. That's Ms. Spurl.
All right, this is 23 CR 000226E, 1 count of theft by taking with Nakia Lee. And it is my understanding, Ms. Lee, that you wish to plead guilty. Is that correct?
Yes, it is.
All right, state.
Yes, Your Honor. Just, is this position 19?
Yes, Ms. Lee.
Okay, just wanted to confirm. Okay, this is the theft by taking. For this, the state is recommending 12 months to serve, 42 days, credit for time served, 21 days, balance probated with an anti-theft counseling, no further contact with the victim, Liberian outlaw, that's LABARIAN outlaw, common spelling, a stay away from the incident location, 355 North Avenue, and proof of employment.
All right. And is that your understanding, Mr. McLean, of the negotiated plea?
Yes, Your Honor, she accepts those terms. She asked the court to accept the terms as well and allow her to plead negotiated for that. She stipulates venue, ID, and factual basis.
All right. Ms. Lee, that's your understanding, is that correct?
Yes, it is.
All right, in order to get your plea, I need to ask you a series of questions. Raise your right hand for me, I'm gonna swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
And the first question I have is, are you under the influence of any medication, drugs, or alcohol not prescribed to you?
No.
And are you satisfied with the services and representation of your attorney?
Yes, I am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes,
And that you're giving up or waiving the right to remain silent and not testify against yourself?
yes, I understand.
And that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, I do.
You put your hand down for me. And are you
Okay.
prepared to agree to waive these rights today?
Yes, I am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No,
Has anyone promised you anything to plead guilty?
no.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, I understand that.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, I do.
All right, and as to the charge of theft by taking, how do you plead?
Guilty.
All right, so again, 12 months to serve, 42 days, credit for time served at 21 days, balance is probated. So you will be on probation until you take your anti-theft counseling. Is that the class, anti-theft class?
Mhm.
Yes, Your Honor.
Okay, and no further contact with the victim, Liberian Outlaw. And you are to stay away from 355 North Avenue, and you're to also provide proof of employment. So
Okay.
you gotta complete all those while you're on your 12 months probation. And then once she completes those, if she completes them before the 12 months, is the state okay with her going non-reporting?
Yes, Your Honor, that's fine.
Yes, thank you.
All right.
That's it. I'm gonna go to my mom.
All right, that will complete and conclude this plea. If there's nothing else, counsel, good luck to you, Ms. Lee.
Thank
That's-
you.
Next, we're going to ACDC, Your Honor.
This is 24 and 25.
Yes.
All right, this is position 24, which is 22 CR 005854C, Angie Spurl, charged with 1 count of simple battery family violence, offense date 8/29/2022. Also, I have case number 23 CR 000362C, 1 count of battery family violence, offense date 9/26/2022. All right, State, Mr. Abdullah, are these your cases?
Yes, these are my cases. Are you ready for me to read the recommendation?
Yes, I am.
So as for position 24, it's the simple battery family violence. The state is recommending 12 months to serve 30 days, credit for time served 1 day, balance probated with a 24-week family violence intervention program. No further contact with the victim, Ayala Bryson, that's AYLA, common spelling for Bryson. A stay away from the incident location, 815 apartment H3, Myrtle Street, Roswell. And proof of employment. That is to run consecutive to position 25. Position 25 is a battery family violence. Same victim, Ayala Bryson. The bond recommendation is 12 months to serve, 90 days, 15 days credit for time served, balance probated with the 24-week family violence class. A stay away from the incident location, which is the same as 24, 815 apartment H3, Myrtle Street. No further contact with the victim, Ayala Bryson, proof of employment, and the 24-week family violence in either case will satisfy them both.
Okay, all right.
I do have a question though. Is the stay away that has been announced, that I think is the family residence of the defendant, her mother, her brother, herself. I think Ms. Bryson does not live there and has not been there since the second incident date. Is that correct?
The state has no objection to lifting the stay away as long as we have like a one-time police escort to just make sure that the victim no longer stays there.
To make sure that the victim, no, the victim hasn't been there since the dates involved are August the 29th of last year and September 26th. And the victim does not live there and has not been there since September.
I think what the state is requesting is a police escort upon her release to make sure we confirm that for the.
Okay,
Okay.
I think that's fine.
Okay, and so that's what I'll put in the order, and they can sweep the premises and make sure that, the victim is truly gone and doesn't live there. Also, it'll protect the defendant from having, any contact as well. So is that your understanding again, Mr. McLean? On both, they're gonna run, consecutive.
Yes,
Right.
Your Honor. They would be appears to be 30 days extra on one as calculated. That's the 90-day one. 90 divided by 2 would be 45 minus the 15. That would be the 30 extra days. The other one would work out to 14 extra days because I believe that was 30 days with 1 day credit, and the math works out to 14. So the total would be 44 days
All right,
extra.
44 days, okay.
So hopefully she will start her probation and the FVIP class as soon as 44 days have passed from now.
All right, great. All right, Ms. Furl, is that your understanding?
Yes.
All right, I am ready to take your plea. I'm going to swear you in first.
Okay.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, and put your hand down for me. Are you presently under the influence of any medication, drugs, or alcohol, and any drugs not prescribed to you?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence to plead guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of these guilty pleas here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right. And for the first case of simple battery for 8/29, 2022, again, you're to stay away from the 815 Myrtle Street, apartment H3 in Roswell. You're to have no further contact with Ayala Bryson. And while you're on probation, you are to take the 24-week FDIP course and provide proof of employment. And once you've done those, then I will agree to you going non-reporting once you've completed all that. And again, with the 24-week FDIP, once you start it and complete it, because if you stop, then you have to start all back over again. All right, so hopefully you will go straight through with it to complete those 24 weeks, and then obviously give proof of employment, and then stay away from that location after you've served your 45 days, okay?
Yes. Can I ask you a question?
Yes.
I still have to look for a job. I might have my family be able to help me out, but is it gonna start like right away? Will I have a little bit of time to like try to get a job lined up?
Well, you're gonna be on 12 months probation, so you will have 1 year to find a job. If you find a job sooner than that, and you also completed the 24 weeks FDIP, you can go non-reporting, but you may complete your FDIP but still not have a job, so you'll still be on probation. Actually 24 months, right?
I believe so, yes.
So it's 24 months probation, right, Mr. Abdullah?
Yes, that's correct.
So you'll have roughly 2 years to find a job, and hopefully you will find it sooner than later.
Yeah, hopefully, yeah.
But you will stay on probation if you still have not found a job until you provide that proof of employment for those 24 months.
Okay. And is the reporting, is that when like you do like the call in like every like month, like every third Thursday or second Tuesday of the month? Is that
Probation will have to tell you that, but it's similar to that. They will tell you what the requirements are for reporting, yes.
Okay,
Okay, all right, good luck to you.
thank you.
All right,
Position 18, Your Honor.
okay.
And Jordan?
All right, this is 23 CR 0000359J. Is it Trinan or Trinan Jordan?
Yes.
Charged with 1 count of battery, a 2nd count of criminal trespass. That offense date is January the 18th, 2023. And what do we have? Is this a plea, Ms. McLeod and Mr. Abdullah?
Good morning, Your Honor. I haven't had a chance to speak with my client yet.
Oh, okay, Mr. Jordan?
Mrs.
Beg of Mr. Jordan to see if he can place you all in a breakout.
But I would like to hear the terms of the,
Oh, I'm sorry.
I'd like
Mr.
the state to
McLeod.
put the terms of their plea on the record so I can discuss it with my client.
Okay, all right.
Yeah. Yes, I can do that.
Okay,
The state is recommending, as for the battery, 12 months to serve, 120 days, 15 days credit for time served, a balance probated with the 8-week anger management course, a stay away from the incident location, that's 1071 White Oak, and no further contact with the victim, Alexandria Bailey. As for the criminal trespass, it's gonna be a 12-month probation to run concurrent, and a stay away from 1131 Lee Street, as well as no further contact with the victim, James Andrew.
okay. All right,
I would like to discuss it with my client, Your Honor.
okay. All right, Mr. Jordan, can we make that happen, I think?
While you're doing that, Your Honor, we can go to position 14,
Okay,
Mr. Aaron.
all right.
Your Honor, while we're going to that position, may I make a few announcements or requests?
Yes, let's do that first.
Okay, number 15 and 27, I'm sorry, 15 and 22 are cases which, due to the nature of the case, before even doing the SAP session, I need to talk to the family extensively, more than the average person. So on 15 and 27, I'd like to reset that to a date of the court's convenience, 5 days, 7 days, next Tuesday or Thursday, or even the week after that, considering what the bonds are and what the situation is. Any of those days would be fine.
Is it 15 and 22 or 15 and 27?
I'm sorry, it's 15 and 22. Now 27 has already been reset once, and I've still been trying to get hold of the felony lawyer. We could go ahead on that and simply do not guilty. Because of the Zoom situation, by the close of business tomorrow, I will find a form and file the waiver of arraignment rather. And I'll talk to the felony lawyer about the bond request. Bond is moot for the misdemeanor at this point because he has an $18.5 thousand felony bond, which he cannot yet afford and which has not yet been reduced. So only if the felony bond is reduced does bond come into play here. For right now, owing candor to the court, it's just moot for us. We're not going to be able to make that bond. So it's not going to harm him in terms of days of custody for him to go to not guilty at this time.
Okay. So
Your Honor,
27 and
Your Honor, as to position 22, that case has been accepted for felony transfer. So we'll no longer be pursuing that case. It's moved up to the Superior Court.
okay.
Good. So 15, I would like to put off to next week or so.
All right, Ms. Champion?
For position 22, have a transfer order been signed, Mr. Abdullah?
I'm not sure, but I'll if not, I'll get that to you.
I believe the order
see
was signed.
I
I believe the
don't
order
see
was
one in-
signed yesterday. I'm sorry.
I don't see it in the system at this time. What judge signed it?
It was in the C calendar, so it was showing
Oh,
off
that
that.
was the one. That was the one that they gave me in the C calendar yesterday.
Yes, yes.
Yes, so it should have been processed with our see paperwork, Ms. Champion, with Ms. Bridgewater yesterday.
I'll check with Ms. Bridgewater when she comes in, but as of now, it's not in the system. And we can reset the position 15 to the next Thursday, the 9th date.
Okay. Mr. Jordan, are you listening to me? Is he still on?
I hear this.
Can you check, or did I copy you yesterday? By chance?
The case number that we're talking about at the moment.
They're talking.
Position number 22, they say a transfer
Mhm.
order.
Right.
Okay,
John
it might be on
Quinn.
this knowledge base. I'll grab it.
And I do recall signing that yesterday. It was at the end of my bond orders, and that was there yesterday. All right, and then let's see, position 15 is going to be reset to 19.
29.
I'm sorry, 29, wrong month, February. Thank you. And then 27 is going to be a waiver of arraignment, not guilty, correct?
Correct.
All right, any other announcements, Mr. McLean?
Your Honor, number 26, let's see, 26 is the last name,
Sterling?
Sterling. Mr. Sterling and I need to communicate more to correct miscommunication. And I've been trying to get hold of his father. I've been leaving messages. Due to the nature of the offer and due to the nature of the bond, there would be no harm in.
Uh-oh, Mr. McLean, did we lose you again? Mr. McLean? You're back. We lost.
Oh, I'm sorry. I was out for just, I had to refresh a second with the, yeah, I was just saying that on Sterling, I need to go to talk to him again. I've been trying to get hold of his dad. I will succeed in getting hold of his dad eventually, but there would be no harm custody wise for me to go to the jail and see him and have him on next week.
All right, so we resetting that, Ms. Champion, to 29.
Yes, ma'am, we can do a one week reset.
Okay.
Now I've got not down here for 17. Which one is 17? Let's see, that's Antonio Johnson, Roman numeral 2, as I put it. Antonio Johnson has 2 cases. One's a time served, but he's one person. So he's stuck for the moment on the second case.
Your Honor, position 14 is waiting patiently here.
Okay.
I think Attorney McLean has a lot to say about the calendar. Maybe that could wait until we clear out.
We'll do that at the end. We'll go ahead and take our.
I'm sorry, probably went out again.
All right, Mr. McLean, last one, and then we're gonna probably take some more pleas and move you to the end, they're saying, because they want to move some of the defendants on. So 17, what would you like to do with that one?
I'll put that on to next Thursday, Your Honor. That'd be fine. I'll talk to him again.
One-time reset to 29.
Yes.
Is that fine, Ms. Champion?
That's position 17.
Yes,
16
John.
and 17.
Oh, 16 and 17. Yes, 16 and 17.
Okay.
All right. And then who do we have before us, deputies?
Position 14, Mr. Heron.
Okay. Thank you, Mr. McLean.
Thank you.
This is 23 CR 0003388. Jeffrey Heron charged with 1 count of SB. Offense date is January the 17th, 2023. What is the status here?
Your Honor, this will be a negotiated plea.
All right. And state, what's the plea offer?
At this time, the state is recommending 12 months to serve 60 days, credit for time served 16 days, balance probated with the SDET course, no further contact with the victim, Ebony Sallie, SALLIE. Stay away from the incident location, 10 Park Place, Atlanta, Georgia, except for official business. And that's all for the state.
Okay. All right, and Mr. Dotis?
Yes, Your Honor, and I would like to just clarify that that address is for Grady Hospital, based on my understanding. But I think we did state that it was except for official business, but did want to point out that was Grady Hospital. We're prepared to go forward with the negotiated plea. We would ask for Mr. Heron's probation fees to be waived to help him get back on the feet, as well as to switch over to non-reporting status upon completion of the SDET course.
All right. And so this is Grady Hospital, and we're saying that he will stay away except for official business or except for receiving other medical services? Is
And
that
medical emergencies. Yes, yes. Your Honor.
Yes, sir. He regularly receives treatment at Grady.
The state has no problem, of course, with we can't object to him going to get treatment. So that's not a problem. We just don't want him loitering there or of course being there after he received the treatment.
Right.
And so is this victim an employee there?
She's the security guard there.
Security guard. What I'm getting at is if he goes there for treatment again, hopefully he won't see the security guard if she's working there.
And that's a good point, Yana. He will. I'm not sure under what conditions we can make the stay away. We just don't want him to have any more contact with her.
Okay, so then there
It probably should be no further violent contact.
Okay, okay. And technically, there is no stay away except for treatment or official business. Otherwise, he should not be at that location if he's not receiving treatment. Is that correct? Okay.
Yes.
Just want to clarify that and make sure that, since he still may be, seeking treatment, I have doctors there, and do his best if he sees the security guard to go the opposite direction if he can. But it's no further violent contact. Okay, that will
be best. Of course, if he needs the help of security for whatever reason, we want him to seek that, but it needs to be only for official business.
correct. All right. Is everyone clear on the terms?
Yes, Your Honor, that works for us. Thank you.
All right, good. Okay, Mr. Heron, I understand that you want to plead guilty to this charge. Is that correct?
Yes, ma'am.
All right, raise your right hand for me.
Your Honor, I do just want to stipulate to the factual basis of an IV. Apologies.
No, my apologies. Thank you. And Mr. Heron, do you affirm that you will tell the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. Are you presently under influence of any non-prescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're waiving or giving up the right to trial by judges, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone told you, promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, and again, to the charge of SB, how do you plead?
Guilty.
All right, and so you understand it's 12 months to serve 60 days, credit for time served is 16 days. The balance is probated. You will stay on probation until you complete the SDET course. And you're to have no further violent contact with Ebony Sallie, the security guard at the Grady Hospital at 10 Park Place. You cannot go to that location except if you're receiving medical services or for official business. And even if you're there, you still to have no violent contact with Ebony Sally. And I will waive 6 months of your probation fees. And once you complete the SDET, then you can go non-reporting. All right?
Yes, ma'am.
All right, good luck to you.
Position 16 and 17, Your Honor, courtroom 2, position 16 and 17.
Excuse me, courtroom 2. Can we go onto position number 18? I have a juvenile case that's going on as well that I have to speak with the judge with.
No problem.
Let me
Thank
say
you.
this. 16 and 17, that's gonna be reset to February the 9th.
Okay, thank you.
And so we're moving to 18 with Ms. McLeod.
Yes, Your Honor.
All right, and what is the disposition?
My client wants to take a blind plea, Your Honor.
Okay.
She thinks that the state's offer is too much time.
All right, and the state was asking for 12 months to serve 120 days.
Yes, Your Honor.
15 days credit for time served, balance probated, and the other 12 months probation was to run concurrent, but how much more time was she gonna have to serve?
Well, they want her to spend 120 days, Your Honor, and she really wants to get out of jail.
Oh, because it's only, but I thought with the 15 days credit for time served, so she's got about, can someone do the math for me?
She's got about, I would say, 60 more days possibly.
I understand, Ms. McLeod. Let me hear a little bit of her criminal history from pretrial on position 18, which is Jordan.
You said Mrs. Jordan, number 18?
Yes. Is it Trenton Jordan?
Yes, Your Honor.
It'll be about 52 more days, Your Honor.
Thank you.
Yeah, if you want, I could read the history.
You have it.
Like we lost courtroom.
I got it.
Oh, pretrial's there. Okay, thank you, pretrial.
Judge, in regards to Ms. Jordan, she has a total of 24 cycles. Okay. Ooh. Prior obstruction, that's old. That's old. A battery, family violence in 2007. Criminal damage to property in 2010. Aggravated assault in 2010. A OFTA in 2014, 2011. Couple of battery, family violence in 2012. A battery, family violence, probation violation in 2012. A battery, family violence again in 2013. Criminal trespass in 2019. Aggravated stalking, criminal trespass in 2022, still on probation for that. Sentence 4/26/2022, 4 years and 99 days, probation 266 days, confinement. Was to complete a mental health evaluation and follow up with any treatment in DeKalb. Took a theft by shoplifting in DeKalb also in 21. And a recent probation violation in 22. Nothing further.
All right. And this was Mr. Abdullah's case.
Yes, Your Honor.
Okay. And so I've heard the offer. And again, Ms. McLeod, you all still want to do a blind plea?
Yes, Your Honor, that is what my client would like.
And tell me about your client, Ms. McLeod.
My client is the mother of 4 children, Your Honor. She tells me that she has been a victim of domestic violence for a very long time, since she was a teenager. She also has some health issues that she's battling at this time, Your Honor. She does tell me that she has a place that she can go to live in Cobb County with a friend, and that is where she's hoping to go when she gets out. Because of what she has been going through, Your Honor, some of her health issues, she hasn't really been able to hold on to a job in recent times. So it's been a while that she's been able to work. So she was essentially homeless, but she's trying to get herself together right now so that she can get on with her life, Your Honor. But she has had some significant issues with abuse from she was a child.
Okay.
She tells me that the alleged victim, even though the warrant said that they did not know each other, is someone that she knows very well.
Oh, okay.
It's not, it was just like, you know, an acquaintance with whom she would smoke and, you know, sit and talk. It was not a stranger at all, Your Honor, which was the allegation that she just attacked this stranger. She said that that is absolutely untrue.
And that's the state is asking for no further contact with the victim, Alexandria Bailey.
Yes, Your Honor, that's the victim in this case.
Okay.
If the state could just place some facts on the record and
Okay.
just make an argument before you make your ruling.
All right, go ahead.
So the state definitely shares the interest with the defendant in getting her home and trying to restore her life and getting her back on track. However, we also have an obligation and a duty to protect the victim. I understand the defense is saying that she wasn't a stranger. Nonetheless, it doesn't change the fact that she was battered by the defendant. The state's duty to protect the victim and the community at large seems to be frustrated by the defendant's extensive criminal history of violent crimes. As you heard from pretrial, she has two convictions for aggravated assault, as well as a conviction for battery, family violence, and a conviction for criminal damage, which one of the charges in this case is a criminal trespass. She was also arrested for simple assault, simple battery, aggravated assault, battery, family violence, another battery, family violence, and she has 3 FTAs that shows a disregard for the orders of the court. Just briefly, very briefly, the facts of this case is that officers were responding to an injured person call at 1071 White Oak, where they met with the victim, Ms. Bailey. Ms. Bailey told officers she was walking past 1071 Oak Street when the defendant asked her for a lighter and other drug paraphernalia. When Ms. Bailey told the defendant she did not have those things, the defendant got mad and punched her in the head. Ms. Bailey did suffer from a laceration on her head and was still bleeding when officers arrived. While they were responding to Ms. Bailey, officers got another call about the defendant trespassing just around the corner at 1131 Lee Street. She climbed over a business's gate while they were closed. That did result in damages to their fence. That incident was captured on video, and she was asked by the owners of the property to leave, at which time she stated some things to them, all captured on video. For that reason, the state finds it appropriate and is requesting 12 months to serve 120 days, 15 days credit for time served, balance probated with 8 weeks anger management, a stay away from both locations, no further contact with both victims. And that's all from the state.
Okay.
Your Honor, I believe this is just a situation where my client has kind of fallen in the cracks. She has been essentially a victim all her life since she was about 13 years old. And whenever something happens, instead of helping her, she's just been committed, you know, and it's just escalated her situation where nobody has tried to rehabilitate or help her in any way. They just send her to jail and then she ends up on the street and the cycle just continues all over again. Keeping her locked up in jail is not going to help her and it's not going to help anyone because ultimately she's going to come out and she's just going to be in a worse place the longer she stays in jail. Nothing further, Your Honor.
All right, and she's served 15 days.
Yes, Your Honor.
In regards to this blind plea, the state's asking for roughly 52 more days. And I have heard the history of the defendant. And with the state asking for 120 credit for 15, I would ask for, and make sure that I'm clear, I will accept the plea with 15 more days to serve. If it's a 2-for-1, it'll be a week, but give or take. So is that something that you all would accept?
Yes, Your Honor.
Okay. All right. All right, that's what we'll do. State, I would rule that I will accept this blind plea and ask for 15 more days of service. And give credit for time served at 30 days of the 120.
Thank you, Your Honor.
All right.
So
All right.
Judge, it will read 12 months to serve, to serve how many days?
It should be 45 days, I believe.
45 days? Okay.
45. Thank you.
Or, yeah. it
And
should be
credit for the
45.
15 days she's already served. Okay.
Right. Thank you. You have to help me with the math. All right. So if we're ready to take the plea, we will do that. Ms. Jordan.
Yes, Your Honor.
All right. You can have to unmute her. Deputies in ACDC, can you unmute the defendant? I think she's way back there. Ms. Jordan, can you ask someone behind you to unmute you so that we can hear you?
Yes, Your Honor.
I think they're coming.
Okay, there you go.
All right. And Ms. Jordan, you ready to take your plea?
Yes, Your Honor, thank you.
All right, you're welcome. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Absolutely.
All right, and put your hand down. And I'm going to ask you a series of questions in order to take your plea. Do you stipulate, Ms. McLeod, to the venue, identity, and factual basis?
We do, Your Honor.
All right. At the present time, Ms. Jordan, are you under the influence of any unprescribed medication, drugs, or alcohol?
No, and I did not attack that woman. She asked me for something.
No,
I didn't
Ms. Jordan, don't speak. Exercise the right to remain silent. I'll speak for you.
Okay.
Just answer my questions, okay?
Yes, ma'am.
Are you satisfied with the services and representation of your attorney?
I am. Thank you.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
And you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
You're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
You are prepared to agree to waive these rights today?
Lewis.
And does anyone that you receive a lesser sentence for pleading? Can you hear me?
Yes.
Okay. Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Understandable.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
I do, Your Honor.
All right, and so again, to the charge of battery and criminal trespass, how do you plead?
Guilty.
All right, and so your conditions again, 12 months, probation to serve 45 days, credit for the 15 to serve, am I saying that right, Ms. Champion? And
Yes, ma'am.
an additional 15 to serve. And after that, your probation your balance will be to complete the 8-week anger management course as one of your conditions. And the other 2 conditions are to stay away from the 10701 White Oak and to stay away from the 1131 Lee Street. Can you do that for me, Ms. Jordan?
Yes, no problem.
Okay, good. And as long as you do that, but you've got to complete your 8 weeks of anger management, you'll be on probation. I will allow you to go non-reporting after that. And remember, no further contact with Alexandria Bailey.
Okay.
And I will waive half of your probation fees, okay? 6 months.
I have a job, Your Honor.
Huh? I'm sorry.
I don't have a job to pay me. probation.
I will waive half of it for you.
Okay, okay.
Okay. And I think that's it. Anything else, counsel?
Nothing further, Your Honor.
Okay. All right. That will conclude your case. Good luck to you, Ms. Jordan.
Thank you.
All right.
Thank you.
Next, we have Justin Singleton.
Your Honor, may I make an announcement?
Speaking.
If I could, before we move on to Mr. Singleton, if I could make a quick announcement.
Oh, okay, Mr. Dotis, yes.
Apologies, thank you. Yeah, it'll be really quick. I just wanted to note to the court that Ms. Kenya Benton is on the Zoom in support of Contrell Hall for position 12. She's been on the Zoom since 9 a.m. I know we have a roaming officer that'll get a jail iPhone to Mr. Hall so we can go forward with his hearing. But I did just want the court to note that his family has been on the Zoom. I don't know how much longer they can stay. Thank you.
I don't know which location Mr. Control Hall is.
Right, and I think officers are on their way and trying to figure that out, and I know we can't do that right now, but I did want to just acknowledge that in case that they have to excuse themselves due to work.
Right, I apologize to the family. Again, some of the logistics I'm not in control of. The jail, I have to defer to them. We'll try to see if we can bring up Mr. Hall soon, and hopefully you can stay, okay?
Yes. Yes, ma'am.
All right, thank you for your patience.
Okay.
Thank you, Your Honor, and apologies for the interruption.
No problem. All right, who do we have next? Deputy?
Excuse me.
Hello?
Hello.
Who's speaking? iPhone, please mute yourself. All right, what it is, are you a family member of a defendant on the calendar? iPhone? All right, who do we have, deputies?
Position, I believe it's position 20, Mr. Singleton from the Compassing calendar. Ms. Maureen McLeod is the conflict attorney for him.
I'm Dennis Murphy. I'm on the other case.
Okay.
Judge,
Yes.
on in July, there was an evaluation done, and he was determined not to be competent. And then subsequently, it was a matter assigned to Judge Taylor, but subsequently he had been released and then got rearrested. I had submitted last week some IST orders to Mr. Jordan for both cases. Because I have spoken to my client's sister and I advised her what was happening, and that there were essentially the family had no resources or anything to assist, so they were aware of what was going on today.
And
There's-
Your Honor, I concur with what counsel is saying, because I actually contacted him. He has two outstanding cases, and Mr. Murphy was representing him on the first one. And at some point, Judge Morad said that it probably would be best for Mr. Murphy to represent him on both, but that didn't happen. But I have been in touch with Mr. Murphy, and I've actually spoke with his sister, and she concurs on what Mr. Murphy is saying. I just had her on the phone not too long ago.
So are there two cases or three cases? I have a Justin Singleton, and a Justin D. Is that the same person for 20, 21, and 22? Or is it just 20 and 21?
It's 20 and 21, Your Honor.
Okay, so that's a different person on 22?
I believe so, Your Honor.
22 has the same date of birth as 21 and 20.
So there may be three cases?
Judge, I was only aware of the two accusations, and on my proposed orders, I had him as Justin D. Singleton, AKA Aiden Jordan.
That is correct.
And then that third case, offense date 8/24/2021 is also a Justin D. Singleton. It looks like the same date of birth as well. That's a 21 CR 00444458. I was just curious again, because I have three cases instead of two.
My apologies, Judge. I did not see anything else on Odyssey other than the two cases. I can always later today submit a third order for the third case then.
So Judge, well, we really don't need a third order for the third case. That was a newly initiated case by the solicitor's office. That 23 CR 000525H. So I added it to the calendar so it wouldn't go to the division because I knew that he was pending the grade evaluation. But we don't need an order on the third case. One order should cover all three cases.
Okay.
All right. And so that is what we will do, the Grady eval, and that will cover all three. Is that correct, counsel?
Yes, Judge, that was my understanding.
Okay. All right, I will, when you submit that order, I will sign it.
Thank you, Your Honor.
All right, thank you. Anything else, Mr. Cloud?
Nothing further, Your Honor. My business is concluded today, Your Honor. May I be excused?
Yes, you may. Have a good one.
Thank
What's
you.
the reset date we're gonna reset the cases to?
Oh, I'm sorry, Ms. Champion. That's important. Can you give us a date, Ms. Champion? I apologize.
How long do the defense attorneys need the case to be reset out? Is it gonna be 2 weeks, 4 weeks?
Well, I'm not sure how long the evaluation will take.
Well, they've done the evaluation. He's now just gonna have to be transferred.
So do we want to reset 2 to 4 weeks out to see if he's been picked up to go to the hospital, or?
Yes, that'll be fine. If we can go 4 weeks out.
Any input, ASG Walker?
Good afternoon, Judge Mincy. That's fine with the state.
Okay.
4 weeks out will be March 2nd.
All right,
Okay.
Thank you.
we'll reset those cases to March 2nd.
Thank you.
Thank you. All right. Who do we have next, deputies?
Position 16 and 17, Antonio Johnson.
Okay.
I believe Attorney McLean requested a reset for that unless something has changed.
Okay.
It has changed,
Okay,
a negotiated plea.
okay.
Okay. Yeah, you're right. Thank you, Mr. Abdullah. We had said. Okay. All right, I have case number 18 CR 005631C. Antonio Johnson giving false name, address, or birth date to law enforcement on December 30th, 2016. I have a second case, 23 CR 000340C. Terroristic threats and acts. That offense date is January 18th, 2023. What do we have as far as the plea offer from the state?
As to count 16, or I'm sorry, as to position 16, given a false name to police officer, the state is recommending 12 months to serve 4 days, credit for time served, 2 days, balance suspended. As to position 17, terroristic threats and acts, the state is recommending 12 months to serve, 90 days, credit for time served, 16 days, balance probated, 24 weeks, family violence intervention. No further contact with the victim, Chelsea Wagner, a stay away from 500 McDaniel Street, apartment 3219, and proof of employment.
Okay. All right, is that your understanding, Mr. Daughters?
Oh, it's McLean.
Oh, I'm sorry, McLean.
Right.
McLean.
I was off the Zoom for a second while I refreshed. And thank you for letting me reverse myself on 16 and 17 on that reset. It is our understanding that with the 90 and the days of credit, that it would result in approximately 29 extra jail days, and he is amenable to that. He would come out of jail and go do probation and family violence intervention program, and he understands the expense and the effort on that. Your Honor, we would ask for a break because that FVIP is so expensive. If the court could waive probation fees, that would be wonderful.
I will waive 6 months of the probation fees. I will do that. I think that is it. We're ready to take the pleas.
Your Honor, if we could just very quickly, the state has no objection to the probation fees. However, we would like to clear up that or just confirm that stay away from 500 McDaniel Street. Originally, I think on the C calendar, the defense was saying that, or he has a previous bond order on a felony charge against the same victim, in which he was ordered to stay away from that 500 McDaniel Street. He was supposed to be on house arrest at 1827 Honeysuckle Drive. Somehow there was an oversight and his house arrest was assigned to the 500 McDaniel Street. On the C calendar, they were saying that the victim does not live there. She does in fact live there. We've reviewed the body cameras. Her child's belongings were there. Her belongings were there. She told officers that she lived there. The defendant made no objection to the fact that she was living there. He told officers that they lived there together. So we just want to make sure that he knows that he can't return to that 500 McDaniel Street.
Okay, as well. And so that is noted, and we will make sure we put that in the conditions. But as far as the 1827, that one he can return to.
Yes, that was the address. So on the C calendar, they were saying he's not associated with that address, but that's the address that he was ordered to live at on the previous 25K bond on his felony charge by Judge Boston.
Okay. All right, we will do that. All right, anything else? And I'll take his plea.
Nothing else from the state. Sorry to interrupt.
That's okay, thank you. Mr. Antonio Johnson, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, and you put your hand down. The first case, again, 18 CR 005631C. I'm going to ask you a series of questions in order to take your plea to give in false name, address, or birth date to law enforcement officers. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No.
Okay, and are you satisfied with the services and representation of your attorney?
No, I'm not, Your Honor.
I'm sorry?
No,
Are you satisfied with your attorney or not satisfied?
I'm not satisfied. He said the questions I'm asking, the quote unquote stupid question. But that's why we don't have took the plea of guilty, because I didn't understand what was going on, and he wasn't trying to explain to me, but I'm ready to take the plea, Your Honor.
Okay, do you understand what you're pleading to now?
Yes, ma'am.
Okay, and do you understand that by pleading guilty, you're giving up or waiving your rights to the presumption of innocence?
Yes, ma'am.
And that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And you're waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
You prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, that your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
You offer this guilty plea freely and voluntarily with the full understanding of the charges against you.
Yes, ma'am.
And as to giving a false name, address, or birth date to law enforcement, how do you plead?
Guilty.
And as to the charge of terroristic threats and acts under the case in 0340C, how do you plead?
Guilty.
Okay, so I've got the guilty pleas on position 16 and 17. I will read you your conditions. On the first case, in 5631C, there's 12 months to serve 4 days, credit for time served 2 days, and balance suspended. The second case of terroristic threats and acts ending in 0340C, it is 12 months to serve 90 days, credit for time served is 16 days. Balance probate, take the 24-week FVIP, no further contact with the victim, Chelsea Wagner, and you are to stay away from 500 Daniel Street, number 3219. And you are to also get proof of employment before coming off probation. What I will do is waive 6 months of your probation.
No, I wanna get bond out.
I'm sorry?
Not you, Your Honor.
Oh, okay, that wasn't him talking. Okay, I apologize. I thought it was him. So we want to make sure again that you have no further contact with the victim, Chelsea Wagner. And you definitely will need the time on probation to complete that 24-week FVIP. So I will waive 6 months of your probation fees to help you out a little bit with that, okay? Anything else, counsel, that I need to take up?
Yes, Your Honor. While I know the term NOLO is sometimes asked for and denied or granted, we're not asking this be a NOLO plea. I would like to state that I believe my client is doing this in his best interest as opposed to allocuting that he did what was in the accusation. So it's more like an offered plea in that sense.
I said the alpha plea. And again, I think it is 29 more days to serve. And that will conclude these cases if all minds are clear.
Thank you.
All right, thank you. Good luck to you, Mr. Johnson.
Your Honor, before we go to 5 North from Mr. Kendall Hall, I need clarification on Antonia Sterling. I believe that's position 26, and Jamie Lewis, position 20. I believe they were reset.
Yes, 26 was reset to February the 9th, which is Mr. Sterling. And what was the other one, Deputy?
Position 20, Jamie Lewis.
Let's see, hold on. I don't have a disposition there. I don't think we discussed position 20.
Right. On 20, that reset to the 9th would be fine.
Okay, so 20 reset to the 9th,
Yes.
which is Jamie Lewis. All right, Deputy, does that help?
Yes, thank you. And courtroom 2 is signing out.
All right, thank you. All right, who do we have in 5 North?
I'm signing back on, Your Honor.
Okay.
This is Mr. Hall. I don't have his position number.
Okay.
Position 12.
Now, this is position 12, Mr. Kentrell Hall, 3 CR 0000336A, charged with 1 count of loitering or prowling. The offense date is January the 18th, 2023.
Come on. Yes.
And this is going to be a plea.
This will not be a plea, Your Honor.
All right, state, and I understand that we have some family members on for Mr. Hall. Are you still there?
Yes, I'm his mom. I'm still here, but his dad had to leave for work.
Okay. All right, Ms. Benton. You can listen in and we'll see. I don't know if I'll need to hear from you or not. Let's see what we have. All
Yes,
right.
ma'am.
All right, state.
Yes, Your Honor. The state did make a recommendation of 12 months to serve 365 days. Credit for the time he served 15 days. And the state is prepared to move forward with bond argument at this time.
All right, and you're represented by, is it Mr. McLean or Mr. Dotis? Oh, Mr. Dotis.
Yes, Judge.
And what is your understanding, Mr. Dotis, of the status?
Yes, Your Honor, we'd like to, I'm sorry, there's a lot of background noise in the room, but we'd like to go forward with a bond argument.
Okay.
We're ready to go whenever.
All right, and I have, you're gonna submit a waiver of arraignment?
Yes, Your Honor, and I'll submit that as soon as we get out of here.
Gotcha. All right, pretrial?
In
Position,
regards to Mr. Hall, there was 3 other cycles. The first cycle was dismissed. The second one was for numerous counts of entering auto, scrolling through. It was 44 counts. But it was transferred because it was juvenile.
okay,
And then the third one was for riot in a penal institution. No disposition.
what year?
2022. And Dodge County.
All right. And Mr. Dotis?
Yes, Your Honor. Mr. Hall is 17 years old. As of this court date, he has been in custody for 14 days with a $5,000 cash bond, which he or his family cannot afford to pay, keeping him in custody. So based on Mr. Hall's age and the time in jail and the family or his individual ability to pay, we are asking for a bond reduction, and we're asking for a $3,000 surety bond. I don't believe Mr. Hall is a flight risk. He's a lifelong resident of Atlanta. And I have spoken to his mother, who's on the Zoom, Kenya Benton, as well as his father, Melvin Hall. I've been in steady communication with them. And as the court noted, they're here in support. Mr. Hall will be living at their address, which I have verified with them. I'm happy to put that in the chat once we get done here. As I say, they're doing their best to support Mr. Hall. Mr. Hall completed the 10th grade and he's currently interested in getting his GED and understands that is something that the court may ask him to pursue. Additionally, he is in the process of obtaining employment at his local Bojangles, and he believes he will be able to continue that process as soon as he's released to keep working and also focus on finishing up with school to stay out of trouble. I don't believe he's a risk. He understands he has to have no further contact with either of the co-defendants, John Quavius Simpson and Tayshawn Garrett. And I was also clear with him that he must stay away from the Quick Trip. I don't believe he's a threat to the community. Again, Mr. Hall will accept any and all conditions this court deems necessary to ensure that everyone is satisfied that the members of the community feel safe. I don't believe Mr. Hall understands the severity of this charge, and he's open to whatever conditions this court feels is necessary to ensure that no new crimes are committed. As noted, Mr. Hall is 17 years old and he has had three cycles. I believe one had no disposition, the other was dismissed. He does have the prior issue with the entering autos, but after speaking with his family, I believe with their support, they'll be able to instill on him that, you know, this kind of behavior cannot be tolerated. And I think moving forward, they're on the same page that they need to support Mr. Hall and help him get back on his feet. Again, there's no evidence that Mr. Hall did not cooperate during the arrest. As noted, I believe the other two co-defendants were actually the ones that did not cooperate. Mr. Hall fully cooperated. And while Mr. Hall was allegedly in the parking lot walking around, I don't think any further acts were alleged to have been committed. I know some weapons were found on the other two co-defendants, but Mr. Hall did not have any weapons found on him. Along with that, and again, Mr. Hall's age of 17 years old, we believe that a reasonable bond not to exceed $3,000 surety would be appropriate to allow Mr. Hall to be released and focus on getting back on track and being a part of his defense.
Yeah, I think I remember this case a little bit from January the 19th when I heard this matter.
Yes, Your Honor, and may the state be heard as well on bond?
Yes. And I was just making sure I kind of remembered the case, and there were guns found as well, so I do. So go ahead, state.
Yes, Your Honor. To supplement this defendant's prior criminal history, this defendant also has a recent conviction from January 17th of 2023 before Judge Roth here in state court. And the case number is 22CR00608-4A. And he was convicted for possession of a pistol or revolver by a person under 18 years old, as well as willful obstruction. And Your Honor, he entered that guilty plea, it looks like on the 18th of January. So less than a month ago, just a few weeks ago, he was released at that time on January 18th by this court. And I'm sorry, January 17th is when he was released and when he pled guilty. And it looks like these charges today stem from an incident that occurred on January the 18th. So one day after he was released from custody for possession of a pistol or revolver by a person under 18, this defendant was back out in the community again in a case that involves handguns. And I would like to note that his sentence in his case from January from last month was that he got 12 months to serve 240 days. He got credit for the time he served 131 days. His balance was suspended. However, he had special conditions of probation to have no weapons, to get a job, to get a GED, and to complete his DJJ probation. So, Your Honor, clearly, he's not complying with his conditions of release, because like I said, this was the very next day. And so we have that he was at a Quick Trip parking lot with a ski mask on his face, walking around with his co-defendants, and concerned citizens, as well as an officer, reported watching this defendant walk back and forth with this ski mask at the Quick Trip. And that's why he's been charged with loitering and prowling, because it caused alarm to people. And they were, according to the officer, they were looking inside of the cars at the Quick Trip and scaring the patrons. And there was not just one handgun recovered as a result of this incident. It looks like there was one handgun recovered from his co-defendant that he was with. And it looks like the handgun was loaded and the handgun was also stolen. So we have that he's got this DJJ hold from juvenile court for 44 counts of entering auto. We've got that he has this prior conviction from just 2 or 3 weeks ago for possession of pistol revolver. And now we have a brand new case 1 day later with him just participating in the same type of activity. And the state would argue that it's gang activity, to be quite frank. When we see entering autos and handguns and strings of these kinds of behavior, the state would argue that it's gang activity and that it does pose a danger to our community as a whole when we have young men like the defendant out in the community brandishing weapons, already have been convicted for brandishing a weapon, and now out again hanging with his friend with a ski mask who also had a weapon. So the state does believe that the $5,000 cash bond that Your Honor set 2 weeks ago is very appropriate, and that there has been no significant change in circumstance to merit a reduction of the bond at this time. He's still an extreme danger to the community. He's still got that DJJ hold. He's going to have to go answer for those charges down in juvenile court. And so the state believes that he needs to continue to have the bond as set. Thank you.
All right.
And if I may respond, Your Honor.
Okay.
Your Honor, again, my client is not alleged to have a gun on his person during this incident. I believe the firearms were located on the person of the other two individuals. There's no mention of gang activity in this warrant, so I don't know where that's coming from, and I don't think that should be a factor today. And again, the state is right to point out that Mr. Hall was released on January of 18th, and then this is alleged to have occurred, I believe, the day after. I spoke to his family to figure out what was going on, and I apologize if I didn't bring this up earlier. But Mr. Hall when he was released, he was scared and didn't think that he was welcome to go home. He's a 17-year-old boy who just was released from custody and didn't think that he had his family's support. And Mr. Hall is here, and I've spoken to his family, and his parents are supporting him. They want him to know that they're sorry that he didn't feel like he could come home and be supported, but he has their support, and they're going to help him get back on track, and so that he doesn't feel that he has no options and has to keep hanging around people that he probably shouldn't be hanging around with. I don't think that this is an issue going forward now that we're all on the same page, and I've spoken to the family, and they're very clear. They've been here since 9 a.m. to show their support. They want Cantrell to know that he is not alone. And so for these reasons, we're asking for a reasonable bond to allow Mr. Hall to get back to his family and get back on track and continue with his life.
All right. And I believe that his mom is here, Miss Benton. Are you still there, Miss Benton? Miss Kenya Benton?
I think we just lost her. I know that they mentioned to me they had to go to work. I'm not sure what happened. She hasn't been able to be on the Zoom video for a couple of minutes now.
Right. Yeah, I do understand. I hear the state's argument, and I also hear the defense counsel's arguments as well, but I am concerned with the conviction on January the 17th, and then this case to come up the very next day, not the next week, not the next month, but the very next day, to be associated with others who may have weapons as well. And when it says that you're not to have any, you certainly should not be around any as well. And that's what usually the bond conditions mean as well, is to not be around or possess any drugs, alcohol, or weapons. And so I am very concerned by that this 17-year-old young man is getting into that kind of trouble. And the history alarms me as well. And that is why I initially set the $5,000 cash bond. And I believe I see Ms. Benton getting on again. Is that Ms. Kenya Benton? Yes. I'm going to give you very limited time. The hour's getting late. And I don't know if you heard some of what was already stated by the state as well as your son's attorney. I will swear you in and let you briefly state what you would like to state for the court, okay?
And Your Honor, sorry if I may interrupt. I see that Ms. Benton has typed in the chat that it's not letting me talk. She can just know that she's attempting to communicate if she isn't able to answer.
Okay, if you're not able to get on shortly, I'm going to have to.
She can now, but you just connected with her audio.
Can you speak, Ms. Benton?
Why is it not letting me hear?
Benton, we can hear you.
Okay, I'm sorry.
All right. Did you hear what I was stating?
No, ma'am, I didn't.
Okay, I'm going to briefly let you address me. This is a bond modification. I am the judge who originally set the 5,000 cash bond based upon the allegations that I heard and the presentation by the state as well as the defense counsel for your son. I am alarmed and disturbed by it and concerned that he took a plea, had a conviction on January 17th. Next day, he is associated with those with guns and things of that nature. Sounds like he didn't go home. He made some bad judgment calls, and he's got some history that concerns me as well. But I will let you speak for a few minutes, but not very long. If you would like to address the
Okay, his past, we know is not good, but when he was released.
Hold on. My question was, would you like to address the court for a few minutes? And if so, I need to swear you in.
Oh, yes, ma'am.
Okay, raise your right hand for me. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And go ahead, you can put your hand down and now state what you were going to say.
We know about his past. It's been ongoing, especially with his mental health issues. However, he went to court. He did sign off. He did, they gave him time served and some charges were dismissed. However, Kentrell was told by an older sibling that we didn't want him home, which when I say we, I mean both me and his father. He comes from a 2-parent household. Kentrell thought that he could not come home. He slept in the park the day before, and the next day he ended up, meeting up with his friends or whatever. It is no excuse for what he did. The thing that I do want the judge to understand is the fact that Kentrell did not have a weapon on him, and the fact that Kentrell was not breaking any crime. He was the only one that actually cooperated with the police. I really do feel like if the miscommunication hadn't been done, Kentrell would have been home because he had just served a little over 6 months. So I believe what pushed him back was the fact that one of his siblings thought that we didn't want him home.
Okay. Did he call you at all?
Yeah, he did try to call, but unfortunately, like now, I was at work. I'm a GM for Bojangles, which is the job that he works for. He works for me as a cook at Bojangles. So it's hard for me to step offline when I'm serving customers to take a phone call. He attempted to call me twice, if I'm not mistaken. But by the time I was able to get to my call to respond, I didn't get another phone call until I was told that he was being rearrested.
All right. Any cross-examination, ASG Campbell?
No cross-examination, Your Honor.
All right. Anything else, Mr. Dotis? And I thank your time, Ms. Benton. I understand that you work and have to keep your job as well. ASG Campbell, I'm sorry.
Just briefly in rebuttal, I had a quick comment. I would say that him going around his friends because he didn't have a place to go, it still doesn't explain why he had on a ski mask. So, that him not having a place to go, that still wouldn't justify him acting in the way that he did at the Quick Trip, which was he was with a co-defendant and they both had on ski masks. They were parties to, it looks like an attempted crime, or the crime itself was loitering and prowling. And one of them had a handgun, and both of them, including this defendant, had on a ski mask. So that's the state's rebuttal on that.
All right, thank you. All right, I am ready to rule. And again, I understand that Mr. Hall is 17, but I think he's old enough to know better. And he's old enough to do better if he wants to do better. And I think he was given a chance. And obviously you need to communicate with your family and parents. And this $5,000 cash bond was because of the seriousness of what was committed. And you certainly don't walk around with a ski mask if you don't intend to do something that is not going to be legal, and certainly not a positive action. And being influenced by friends is also a problem, and you're going to have to get a hold on that, Mr. Hall. So what I'm going to do with the bond, I'm going to leave it at a cash bond, but I'm going to lower it to $3,000 cash bond. And with that $3,000 cash bond, it's going to be the same requirements or the same conditions. No further contact with Kayshawn Garrett or Jamon Vias Simpson. You're to not be around them and not be around anybody that has guns, no drugs, alcohol, or weapons while on bond, and to not be around anybody else on bond if you make bond. And you to obviously stay away from that quick trip on Sidney Marcus Boulevard. And if you make bond, you would still need your mom as a co-signer. But I'm going to leave it at the cash bond. I want to also, Ms. Champion, add to the bond that if you make bond at the $3,000 cash, that you enroll in a GED program and start working on getting your GED, because that's going to allow you to get a better job, maybe better than you can get without having an education. A lot of times people do things because they don't feel like they have other ways to make money or other ways to do things. But if you get your GED, you'll find that it's a little better. So that is the best I can do. And I hope that you're ready to turn over a new leaf and kind of get yourself together and not hang around those that will get you quickly back into the Fulton County Jail. Thank you.
Thank you, Your Honor.
Thank you.
Understood, Your Honor, and I'll submit that proposed bond modification as soon as I get back to the office.
Okay. All right. Thank you.
Your Honor, can we go to position 18 on the competency calendar?
Okay. And thank you, Ms. Benton. Good luck to you all.
Excuse me.
Yes.
Did they ever find my son, John Quavius Simpson?
Who's speaking?
This is his father, John Simpson.
I believe that was the felony transfer that was signed yesterday, Your Honor.
Oh, that's the case we were talking about earlier. Mr. Simpson, I usually don't talk to people I can't see, and I see there you are now. That was transferred yesterday, the felony, the DA's office. I signed an order yesterday transferring this case to the DA's office.
A felony?
He's being charged with the felony now.
What type of felony?
I don't have that in front of me, Mr. Walker. I don't know if you do or not, but
I believe a gang activity charge, Your Honor.
Gang activity charge. Thank you, Ms. Campbell. You can, where will he be able to get this information? Call the PD's office, I guess.
Call who?
That's correct, Your Honor.
Call the public defender's office. So
Yeah, I tried calling his public defender 5 days straight. This lady won't call me back. They're not answering the phone, but I was never informed that he had a felony charge. how did he get a game charge?
I'm not at liberty to discuss that. It's not on my calendar today. Can
Okay.
Otis or Mr. McLean or Mr. Dennis give him a better number to call to get information about his son's case?
So what happened to his charges with this case?
They
They'll
were
deal.
upgraded to felonies and transferred to the DA's office.
Oh, wow.
Yeah. Can someone from the PD's office give him a number to call to get information?
Well, the main number, of course, is 612-5200 with a 404-612-5200. And there is a
612.
receptionist.
Hold on a second. Say that a little slow for him. I'm
100.
writing it down.
612 5200.
Right. That's a
404.
Now, do you know the name of the young lady that you were trying to reach?
Absolutely not, sir.
Okay. So what we can do is look up on Odyssey, get the case number, and find out what courtroom it's going to and see if it's been assigned to an attorney.
I see a name of Louisa Pinto was appointed to
what I-
represent your son.
If somebody can his phone number and text it to me at 770-891-4755. I can find out whether or not it's a public defender or a conflict defender or what.
Hold on.
Okay, I'll send you the phone number
It's
for
a PD.
Louisa Pinto. She's
Okay.
a PD.
Oh, okay. Yeah, I got her number. That's who's representing him.
Okay.
And she
We can
may
get
be
it back.
in court,
We can
she
get
may
it-
be in court and is not able to call you back immediately. But that is who they have, and you have her number. Just keep trying, keep calling. Eventually she will call you. Maybe she's in court this week. And speak with you. Any
Yes,
other
public-
advice you all want to give him? I'll let you do it real quick, and I've got to move along.
All right, thank you, ma'am.
All right, thank you.
All right, y'all have a blessed day.
Your Honor, position 18, we can disregard that one. She's gonna be reset to next week, but I also have a Miss Penn to add on calendar for competency calendar.
Okay, hold on. So 18 is going to be reset to February the 9th.
That's correct, Judge. Good morning.
All right. And
Afternoon,
then-
actually.
I'm sorry, I'm looking at 18 on the wrong calendar. That was 18 on our,
18 on the competency calendar.
oh, Robinson, right?
Yes, ma'am.
Okay, all right. And then who are you telling me next?
Miss Penn.
And Judge, good afternoon. This is Derek
Oh,
Howard.
good afternoon, Mr. Howard.
Ms. Penn is not on our formal calendar, but I we would need a breakout. I wanted to ask the court or advise the court of something related to her.
Oh, she's not on my calendar. No wonder I'm
Right.
looking.
Yes, she's actually on next week's competency calendar. She was on last week.
Oh, okay, all right. Mr. Jordan, I think he's my Zoom master for today. And I think ASG Walker, who else wants to come in?
Ms. Burgess, Kia Burgess as well. Yes.
And Ms. Campbell can join as well, please.
And I'm here as well, Judge.
Okay, and
So you don't need to be in on that one, Mr. Murphy. That's
Okay.
just our client. Yeah.
Okay, yeah, because I thought I'd seen Miss Daniels there before. So, but yeah, okay, I'll stand. I don't need to be in.
Okay.
Have we concluded with the SAP calendar?
The value of it.
You say y'all done with the SAP now?
I'm not, have we moved on to competency? Did we finish all positions or?
I'm not sure. Let me go check real quick.
Continue on, grab them back. And action on. Hey. I was saying, police up here, where, one of the police that without paperwork, look very familiar with me, you know, since the middle of last year, we're going through stages, the things are important, but never had any problems, never had.
Mr. Jordan, can you put Quorum Two in the breakout room, please, for the competency calendar?
Might be, I don't know.
He said that the only position was left was position 21. I'm not sure what the announcement is on that one.
Okay, I know that's a conflict. We also have, I think, a bench warrant to discuss as well. I think Attorney McLean is handling that one.
No, oh, that was supposed to be Ms. McCall's case. I think she may have left.
Mr. Jordan, can you put Courtroom Two in the breakout rooms?
Nothing there. But you take it away, workers, and call the police.
Hey. Why have they got me in a breakout room? Hey, Dennis.
Hey, Michael. No, I'm actually just, I had someone else on the competency calendar. I thought I saw her. I had a brief announcement, so hopefully they'll get back to us.
Right. Yeah, I'm just trying to reach Narquette Scott, who I've chatted to him to call me on the desk phone that I'm at.
Yeah.
See you.
See you, bud.
Please leave your message for 4709407.
Ms. McLean, who's doing the DV case?
Hello? Hey, Michael.
Who's doing the DV case? There's a DV case on the calendar?
There's a Narket, yeah, see you all. There's a Narket Scott that I was trying to reach at the phone numbers that were in Odyssey, but I haven't reached him. And I see I have chatted to him to call to the desk phone. Now the desk phone, I don't know that he saw my chat because I don't think he's tried to call.
Okay,
Well,
so I think, so we should be pretty much done with the SAP calendar. And we should only be down to the competency cases. Mr. Scott, are you, can you hear us?
Mr. Jordan, should I stay on the call?
Oh, it looks like they're coming back out now. I'm not sure if they're going to take any fees or not on the competency calendar.
there we go. Yeah, I chatted to Narket Scott to to call me at 613-5289, but I don't know that he saw it.
Okay.
Good afternoon, Mr. Jordan. How are you? This is Attorney Mondelli.
Doing all right, sir.
I'm just calling to check in to see where I need to be on the competency for Mr. Alexis.
Oh, so the judge just came back. I think they'll finish it up now.
All right, appreciate it.
Judge Mincy, you are on mute.
Hold on, sorry. Where are we with the jail? I see courtroom 2 there. We're trying to finish up our state all purpose so we can get to the competency. So Mr. Mondelli, we're running a little behind. We're getting there, okay?
No worries. Thank you, Judge.
Yeah, thank you for your patience. Deputies, who do I have? I have a few more cases, or am I all done? Ms. Champion, with my SAP calendar.
I think the SAP is all done, Judge. We only have the DB case that's waiting. And that's Mr. Scott. I don't know which public defender is handling that case.
Okay.
I would like Mr. Scott to call me at 404-613-5289, if he could. That's 404-613-5289, if Mr. Scott could call me.
I think he may be having some technical difficulty because we kept trying to talk to him and now he has his hand raised. So I'm not sure he can even hear us. And I tried to send him a message, but that didn't work either.
I'm right here, sir.
Oh, okay.
Hey, Scott, how are you doing?
I'm okay.
Can you call Mr. Scott? Can you call Mr. McLean? That's me, Mike McLean, at 404-613-5289.
Hold on, could you repeat it then one more time?
Sure. 404.
Oh my goodness. Hold up. 404. Okay.
613.
613.
5289.
Oh, you got too many people talking at one time.
404-613-5289.
Okay, I'm gonna call you right now. So
Okay,
do I leave this video chat or what?
Well, if you're doing on the same phone, call me. You might have to leave and come back.
Oh, are you on the same phone that you're on the camera with?
Yes, ma'am.
Oh, well, you may have to leave and come back. I don't know if you know how to maneuver doing all that. And we
I'll
don't,
figure it out.
yeah, we don't want to hear your call, so you have to make sure your number one is that you're muted. But then you can.
Okay,
I can put them in a breakout room and save everybody.
Okay, I'll figure it out.
Hold
No,
on.
stay there. I'm gonna put you in the breakout room.
Idea, because he's on Zoom and I'm on Zoom. Why don't we do that?
Right. He's gonna put you in a breakout room.
Okay.
Okay. All right. That's the one bench warrant. And let's see.
Yes, we can go over the SAP calendar, or we can go into the breakout room to finish up the competency calendar, whichever one you want to do, Judge.
Does anybody have any? Oh, because Mr. Howard is here to do the competency.
Yes.
I would prefer a competency, please.
Yes,
Competency.
me as well.
That,
Yes.
you say competency?
Please. I have a 1 o'clock meeting, so
Yes.
Yes, all right. Thank you. Mr.
thank you.
You see how my influence is today, right? All right, let's go ahead. Who do we have first? Number 1, Zachary Elect.
That's my case, Your Honor.
Michael, could you put courtroom 2 in the breakout room as well?
Okay.
Thank you.
Judge Mincy, you're on mute.
You were saying, are we reconciling or not? Whatever you guys want to do. I don't have anybody left, do I? Miss Campbell and the court reporter. Mr. McLean is staying with us.
There we go. I talked to Mr. Scott about his bond situation and the address.
Okay. Right, what does he want to do?
Your Honor, Mr. Scott is asking the court to give him another chance and forgive the failure to appear in court. Apparently, the failure to appear in court happened in the late spring of 2022. The alleged incident was March the 9th, I think. And on March the something, right afterwards, March 10th, he gave the address of Scott Street. And then the next day, it says that there was a creation of adding the apartment number. But he says, I was told to stay away from there. So I did end up moving. I moved so I would not, I wouldn't be around there. And his bonding company got hold of him, and he immediately responded to his bonding company by coming down to the courthouse. But by that time, gosh, it had gone into, 5 days in October and November. But he did understand, as soon as his bonding company got hold of him, he said, no, I don't skip court. I've worked full time. He works in a company, I believe it's pipe fitting, he said. And he says, I don't miss court. I just, I go to court every time I'm supposed to go. And he's very sorry that he didn't update his address in time with the clerk's office. He made attempts, he says, to go down to the courthouse. He did go down to the courthouse, and somebody tried to look up his name and failed and couldn't find his name. Now, I don't know if it's an unusual spelling of Narket. Usually people think that's an M. Certainly I made that mistake when I was trying to figure out the case yesterday. I kept thinking M, and I was going with N. But I don't know what the problem was, but he says he came down to the Fulton County Courthouse, tried to get people to look up his name, and they could not find it. And so as soon as somebody got hold of him from the bonding, of course, he made bond. Then he came down to the courthouse and said, "What's up?" and gave him the case number, I suppose. So he does ask the court to forgive him this time and give him a second chance, and he'll make his court dates.
State.
Yes, Your Honor. I would object to the bench warrant being set aside. Just briefly, I want to note that this defendant does have a prior conviction for battery family violence. I'm sorry, he has a prior arrest for battery family violence in 2020 out of Paulding County. I didn't see a disposition listed. Also, just to briefly put the facts on the record, he's alleged to have smacked his girlfriend with an open hand after telling her, "I'm going to smack the shit out of you." He also struck her a second time after the first lap, and it caused scratches and bruising and swelling to her face. While I can't appreciate that he didn't receive a notice, because I do see the notices were returned. It is the defendant's responsibility to update the court of his address. That's every defendant's responsibility to do so. So the state's concerned that he didn't do that. And the state's also concerned that because he has a prior arrest pretty recently for the same type of conduct, that the bench warrant should not be set aside. Nothing further.
All right. And this is March the 9th, 2022. ASG Campbell, do you show how many cycles overall?
I only listed the cycles that were relevant to this case, but if you'll give me 1 second, I can pull up his entire history.
Okay. Because I think pretrial is gone. Pretrial still there? No, I think they're gone.
Give me 1 second.
Okay.
Okay, so it looks like he had. So as of the time of this incident, because we haven't ran into GCIC recently, he just had 3 cycles, and they're all for, it looks like cycle 1 was in 2012, and it was driving without a license, fugitive from justice. Cycle 2 was the simple battery family violence out of Paulding County in 2020. And then it looks like cycle 3 was this case. So
Okay.
just 3 in total.
Okay. It's just that it went kind of long. You know, sometimes I get it just a few months after. And the court date, I think, was June. What did Ms. McLean say?
The court date, it looks like, was May 16th, 2022. It was arraignment.
Okay,
Dated arraignment.
okay, May, okay. So from March to May. And how much was his bond amount?
He had a $1,500 good bond.
All right, I'm going to give you one more chance, Mr. Scott. You know, I understand you're working, and we're gonna give you one pass, okay? And,
Yes, ma'am.
just keep up and do what Mr. McLean says, and if you don't keep it up with Mr. McLean, you have the responsibility yourself to come down to the courthouse. And it's not about looking up your name. You know you have a case. And you see that case number, that 22 CR 001296H.
Yes, ma'am.
That you know, always track you by that and your date of birth. So when people tell me they came down to the courthouse and nobody could find their case, that one is a little stretch for me. Even with the misspelling of the name, they can go by date of birth and find people with interesting different spellings of their name. So now you have your case number, so keep up with that. And that is the way you get information. You know, if you come down or need to change your address, you can't get Mr. McLean, just come down yourself and update your address, okay?
Yes,
Now,
ma'am.
I believe his address with the Odyssey is now correct. And I'm back, Your Honor, because my phone, right in the middle of everything, my phone died and I plugged back in.
Well, I thought you said Scott Street. So is it Mr. Scott living on Scott Street, or did you just state that?
No, he's in Odyssey as of January 25th. He had updated Odyssey. He's at Chateau Forest Apartments, 700 Chateau Lane, apartment 147. Or is it 247 or 147?
30247.
Yeah, 30274 or 30247 is the zip code. So
Okay.
apparently it is correct now. And
All right, we'll give you that one pass. And you know, again, apartment numbers sometimes get left off a lot. And so, and those are the things that make it non-deliverable because they're not gonna figure it out. So I always tell people, when you have apartment numbers, make sure it's on there. And it doesn't hurt to double check sometime, okay?
Yes, ma'am.
All right, good luck to you.
Okay, could I at least know my next court date so I don't have to be late or have this bench warrant issue going on again?
Ms. Champion, do we?
No, the case will be sent over to the divisional judge and they'll assign the next court date. You'll get that in the mail. So please make sure your address is updated, and you can always call the clerk's office and give them that case number and they'll check for you.
Okay, thank you.
I have some defendants have said that they call once a month or every couple of weeks, just checking. The clerk's office doesn't have a problem telling you there are no dates yet. Because it goes back to the division judge, they will send out those notices, but I have heard some people say that they call at least once a month and just check.
Okay, I can do that. I call once a month just to make sure if I don't get nothing in the mail, that'll be okay.
Yep, that is fine. The clerk's office is there for that. All right.
Okay.
Thank
So
you.
my bench warrant is lifted?
Yes, your bench warrant is lifted. I'm going to not revoke you, okay?
Yes, ma'am. Thank you so much.
All right, you're welcome.
Okay.
All
Thank
right.
you.
All right, we can reconcile.
Okay, and Mr. McLean, I need that order to set aside so the judge can sign it too, also on his bench warrant.
Okay, I'm gonna come downstairs. I'm on the second floor right now.
Okay,
Okay.
Thank you.
I can go over the SAP calendar right quick with you guys.
Okay.
Position number 1, 2, and 3 were all pleas. Position number 4 was reset further notice, jail jury, waiver of arraignment was filed. Position number 5 was a non-negotiated plea. Position number 6 was a nolo plea. Position number 7 was a null pros. Position number 8 was reset further notice, jail jury, arraign. Position number 9 was waiver of arraignment, reset further notice, jail jury. Position number 10 was a plea. Position number 11, reset further notice, defendant was released. Position number 12 was a bond modification of a $3,000 cash bond, reset further notice, jail jury. Position number 13 was a plea. 14 was a plea. Position 15 is reset to the SAP 2-9. Position 16, 17 was a plea. Position 18 was a non-negotiated plea. Position 19 was a plea. Position 20 was reset SAP 2-9. Position 21 is reset further notice, jail jury. Position 22 was transferred to the DA's office. Position 23 was a plea. 24 was a plea. Position 25 was a plea. 26 is reset SAP 2-9. And position 27 was waive arraignment, reset further notice, jail jury. Any questions? Oh, I'm sorry, we have an add-on, and the add-on was add-on 1 was a plea. Any questions?
No, ma'am, that will do it.
The no process go to you, Ms. Champion?
Yes, ma'am.
Okay, thank you.
All right, thank you, Ms. Campbell, appreciate it.
No problem.
All right, bye-bye.